In item number 2, we have filed one additional affidavit. Kindly allow us to call for the records, Lordship.
May it please your lordship. In item number 3, I have similar prayer, your lordship. Oblige, sir.
May it please your lordships. My lords, similar prayer in item number 9, my lords. The reply affidavit may be tagged. Item number 9, deeply obliged.
May it please your lordship. Lordship, is a similar player with regard to item number 5. Lordship, we're filing an affidavit in opposition. Lordship, much obliged.
Yes, what is the progress?
My lord.
Take your matter after item number 2. Take your breath. Take a breath. Yes,
My lord, on the last occasion, my lord was listed on 14/7, and my lord asked for 2 queries. One with regard to that notification, gazette notification, it is not there. And so far with regard to 12A, it's not 12A. And my lord, what I have understood with regard to this, my lord, being that BTC now the government has been part of the here government, there are 2 ways with regard to change the law, which has been adopted by the Assam government 1886. Now, one way is that to move an amendment there in the assembly itself, wherein it can be voted and that amendment can be brought in that way. Apart from that, my lord, the BTC can have its own rules subject to a constitutional governor. It is passed by the Council of Ministers. These are the 2 ways. That way, that law can be changed, my lord. Otherwise,
এই হেলা এখন কাগজ এখন ওলাইছিল নহয়। On the BTC.
and this book, my lord, I have handed over 1 copy, my lord.
The BTC. On the Constitution 6th schedule amendment. The BTC.
It is Sarok Didi. These are all notifications, gazette notification and everything, my lord.
Do we have the Constitution amendment?
Yes, it is there, my lord.
Where is it?
Yes, I'm coming to it, my lord.
Yeah. Where?
Gazette notification, my lord, 57, my lord. Yeah,
Here you find page 58.
50, yes.
In paragraph number 2, in subpara 3, after the proviso, the following provisos shall be
Yes.
inserted. Provided further, the district council constituted for areas shall be called the BTC.
BTAD, yes,
It will be called the BTC.
yes. Area district. Shall be called BTC, my lord.
Therefore, it comes, the BTC comes.
Yes, true, my lord. I'm thankful to your lordship to pointing it out, my lord. It escaped my eyes, my lord.
But don't you think it is high time the publishers should be brought to the notice
Yes,
about
of course,
this
my
thing?
lord. Yes,
Why they have put it out there in this particular manner?
yes, that's true, my lord.
The Constitution, if you see the 6th schedule, they
Yes.
didn't insert these.
Yes,
It should not be a part of the footnote. It
yes,
should be a part of it where they may put a asterisk
absolutely,
that
my
it only applies for the territories of BTAD.
absolutely, my lord. My lord, while disposing of, my lord, can put that into so that I can put it and do the needful, my lord.
No, I think you should put it up. You are the BTC
Yes,
council.
I
I
will
think
try, my lord.
you need
If
to
it's been
need
reflected
to
in the
bring
order,
the
they can
notice
understand
of
the
this-
consequence of it.
of this universal on this thing.
Yes,
But they should put it in a different manner,
yes,
because otherwise it becomes, it is not accurate.
absolutely.
So therefore, the very jurisdiction of the secretary,
Yes,
not the,
not there. And it is not gazette notification and it's not a notice under 12A also. And
because it even doesn't say to be a notification. If you see, rule, clause, paragraph 12,
yes, no,
it says public notification.
public notice. It is not there, my. That
It
is
has
my
not been
instruction.
gazetted.
Yes,
Cannot be a notification in terms of 12.
absolutely.
So therefore, on the basis of that, the secretary could not exercise the power.
Power of my appellate jurisdiction.
Now, one thing is this, we hold it, this will have to be said to be prospective
My lord,
with this particular thing.
my lord.
Because otherwise there are many other
Many, my lord.
decisions which may be impacted.
Yes, affected, my lord. That will be prospective.
But the question is, can this court so as under Article 2 to
My lord, it was never been challenged.
Prospective.
Never been challenged, and this decision has been there all along. And now,
Can very well make it that this shall not impact all decisions which have been taken.
yes,
till
my,
now.
that observation will help, my.
And subsequently, any decisions
Yes.
should not be taken on the basis,
My-
unless you bring an amendment or this is being done in accordance with
With
12.
12.
That is the.
Unless it has been challenged, lordship, if anybody comes to court challenging any other order passed by secretary earlier, lordship, then
Then that observation will help us. Because
That is
it
why
will not.
otherwise-
unless
know.
until it
Well,
is challenged,
I
lordship,
have to mention that this would not reopen a case.
lordship,
This decision shall not reopen a case
lordship.
wherein the proceedings or any issue have been settled
Yes.
already.
Yes,
lordship,
In respect to subsequent things,
lordship.
subsequent including yours, this shall not be followed
Yes.
unless it is being notified in terms with 12A.
yes,
Lordship.
that will do, my.
Heard Mrs. R. Chaudhary, the learned senior counsel assisted. Yes, you have to say anything, the other respondent? Okay, you do one thing, I'll give you the liberty to file an appeal before the Assam Board of Revenue. Who has filed the appeal? You filed the appeal.
Yes, lordship. 7 and 8, lordship.
You filed the appeal before the DC, the secretary.
Secretary.
None appears for the respond number 7. Ask your senior to come over in the meantime.
Lordship, I apologize. My senior colleague, Mr. K. N. Chaudhary, sir, is on legs in court number 6.
So what? Hardly matters. In order 17 rule 1. Because of her senior being present in some other court doesn't grant you a grant, doesn't grant you a relief for an adjournment. We dispose of, by the time if he comes, it is well. If he doesn't come, we'll record your name or we'll show as non-appearance for the respond number 7. Heard Ms. R. Chaudhary, near counsel assisted by so-and-so appearing on behalf of the petition. Near counsel as well as the standing counsel, senior standing counsel, ETC, assisted by Ms. N. Chaudhary, appears on behalf of the respondent, appears on behalf of the respondent numbers 3, 4, say 6. 5 hole Mr. Chaudhary, this particular notification has no, this is not a notification. That is not a notification. The liberty to you to file an appeal before the Assam Board of Revenue.
With the aggrieved party.
But they agreed.
Ah.
To giving you the liberty to file before the Assam Board of
But
Revenue.
apparently, my lord, under paragraph 12A.
It has not been notified.
Acha.
That will not be.
See, 12A categorically mentions public notification. It is not gazetted. it has not been notified to anybody. It is only in the,
Fine.
so that is the only way how
Milan,
we can.
Milan. Formula, it will be open for them, anyway, it is for them to take a call.
If you are aggrieved by that decision
Ah.
passed by that settlement officer or whoever it is, you are at liberty to file a, within
Before the Assam
30
Board of
days
Revenue.
for filing an appeal.
Milan,
And here, as I am setting aside that particular notification also, that notification has no value. I'm putting it on my, I would also mention that in respect of all matters which stood closed, then
that will be not be
basis
reopened.
of this judgment, it shall not reopen.
Reopen.
However, in future, if they can only do so by notifying it in terms with 12A.
12.
So appears Mr. K. N. Chaudhary, assisted by so and so, appears on respondent number 7. 8A to 8D.
So Lordship's kind permission, Milan.
Mr. B.J. Talukdar appears on behalf of the respondent number 2 and number 5. 2.
Five.
Settlement of. Assisted by so and so. You are paying for? The present petition has been filed by the petitioner. Assailing the order dated 25/5/2023, passed by the Secretary, Land Revenue and Disaster Management Department, Boroland Territorial Council, Pokrajhar, Immutation Appeal Number BTC LR-688/2022, as well as the consequential order dated 17/6/2023, whereby the names of the petitioners were struck off on the basis of the order dated 25/5/2023. The brief facts led to the filing of the present writ petition are a plot of land at measuring 1 bighah 2 katha 11 lectures covered by dark number 16/69 plots of land, that is, and measuring 1 bighah 2 katha 11 lectures covered by dark number 16/69, semicolon. Land measuring 4 bighah 3 katha 11 lectures covered by dark number 77/187, and land measuring 1 bighah 3 katha 10 lecture covered by dark number 78/88 under patta number 139/195 and final khatiyan number 10 of village Khanabari, Oriani, part 2 under Bagribari Revenue Circle is claimed to be under the ownership and possession of the deceased father of the petitioners. After the death of the petitioner's father, the 5 sons, that is, the petitioners, the respondent number 7, and the predecessor of the respondent numbers 8A to 8E, inherited the said property left out by the deceased father. It is further claimed that out of the amicable settlement between the petitioners and the private respondents, the immovable property left out by late Abdur Rahman Talukdar was divided, properties left divided amongst the petitioners and the private respondents. It is further he averred in the repetition that certain disputes arose between the brothers, that is the petitioners as well as the private respondents, which led to the filing of a suit being title suit number 28/10 against the petitioners and the private respondents. Number 7. However, the said suit was dismissed for default as the predecessor in interest of the respondent numbers 8A to 8E did not take steps in the case. It is further averred that the private respondent number 7 as well as the predecessor of the respondent numbers 8A to 8E filed a miscase bearing number 3/2000/22 before the Assistant Settlement Officer Bagribari for striking out the names of the petitioners from the land at measuring 1 biga 2 katha 11 lechas under Dag number 16/9 of Patta number 139/195 of village Honabari Oriani Part 2. It is also stated during the pendency of the said miscellaneous application, the present petitioners filed a petition before the settlement officer Dhubri and Kokraja, praying to stay the miscase number 3/22 before the Assistant Settlement Officer Bagribari Revenue Circle, stating inter alia that they are the exclusive owner and possessor of the land at measuring 0 biga 4 katha 15 lechas out of 2 katha 11 lechas covered by Miyadi Patta number 139/195, Dag number 16/69 of village Khanabari Oriani Part 2. This case, which was filed before the settlement officer Dhubri and Kokraja district, was registered as miss case number 2/2022, and notice was issued to the private respondent number 7 and the predecessor in interest of the respondent number 8A to 8E. The private respondent number 5, 7, who filed the objection? In the miss case 2/2022, who filed the objection?
The private respondents, 7 and
Who? 7 or 8?
7, 8, both lordship.
They have mentioned as 5 in your petition.
Lordship.
The private respondents herein filed their objections stating inter alia that the sale deed by which the petitioners were claiming ownership and possession was a forged document. It was also pleaded in their objection by the respondent number 7 that on 4/5/1961, one Mohammad Mojifur Rahman Talukdar, being the cousin brother, gifted the land at measuring 1 biga 2 katha 11 lechas covered by Dag number 16 and measuring 4 biga 2 katha 11 lechas covered by Dag number and measuring 1 biga 2 katha 10 lechas covered by Dag number 78. 2. Who is the opposite party?
Lordship 7.
To the respondent number 7
An objection was filed by 7.
by executing registered gift deed number 4264 of 1961. Accordingly, on the basis of the said gift deed, the said land were mutated in favor of the private respondents. The settlement officer, next, after hearing the parties on 27/2022, held that both the sale deed number 1326 dated 27/3/2004 and the gift deed number 4261 dated so and so are susceptible and cannot termed as forged as per the Assam Land and Revenue Regulation 1886. It was held that since the title holder is in possession on the entire land, cancellation of the name of the recorded pattadars cannot be justified. It was further held that although the land measuring 1 biga 2 katha 11 lakhs covered by dark number 16/69 is a vacant land as stated by the ASO Bagribari, but the name of both the parties have already been recorded as pattada in the Miyadi Patta land in question. Under such circumstances, the settlement officer did not interfere in the matter for cancellation of the name of the present petitioner from the record of rights. Against the said order, dated 27/2022, the private respondents as well as the predecessor in interest of the respondent numbers 8A to ET preferred an appeal before the respondent number 4. The said appeal was registered as mutation appeal number BTC -688/2022/2. The respondent number 4, by order dated 25/5/2023, cancelled the mutation order dated 24/3/2021, passed by the Assistant Settlement Officer Bagribari in favor of the petitioners. On the basis thereof, the records were corrected by the Assistant Settlement Officer by an order dated 17/6/2023. It is under such circumstances the present writ petition was filed by the petitioners. This court duly takes note of that when the present writ petition was filed, the learned coordinate bench of this court by an order dated 13/10/2023 issued notice and further directed that status quo as regards the land in question be maintained till the returnable date. The records further reveal that the interim order thereupon have been continued from time to time. In the present proceedings, various issues pertaining to facts have been raised by both the parties in the present by filing their respective pleadings. However, it is very pertinent to take note of that by an order dated 27/8/2024, this court took up the issue which was most fundamental to the present proceedings as to whether the Secretary BTC at all had the jurisdiction to entertain the appeal against an order passed by the settlement officer. Eight and 9 of the order dated 27/8/2024 being relevant is reproduced hereunder. This court have duly heard the learned counsels appearing on behalf of the taking into account the jurisdictional questions which have been raised in the instant proceedings. This court heard the learned counsels appearing on behalf of the parties. Where's the document notification?
It's three different options.
Page 47 of affidavit in opposition of BTC, Lordship.
Fusto. The issue. Fusto. It is the stand taken by the BTC. By the respondent number 3, 4, and 6 in the affidavit in opposition dated 19th of July 2024. That the exercise of jurisdiction by the respondent number 4 is on the basis of a notification dated 30/12/2016 issued by the Principal Secretary, Boroland Territorial Council, whereby the powers of the Deputy Commissioner as provided under the Assam Land and Revenue Regulation 1886 was vested on the Director of Land Records, Survey and Inspector General of Registration of BTC. The appellate authority in that context was the Departmental Secretary of the BTC. It is also seen from the very notification dated, taking into account the importance of the said notification dated 30/12/2016. The same is reproduced hereunder. The question arises as to whether the question in the present proceedings arises as to whether on the basis of the said notification, can the order passed by the settlement officer be challenged before the Secretary BTC, concerned Departmental Secretary BTC, who is the respondent number 4? For the purpose of deciding the said, it is relevant to take note of that a memorandum of settlement was entered into by and between the Government of India, the Government of Assam, as well as the Boro Liberation Tigers on 10th of February 2003. The said memorandum of settlement was entered into with an objective to create an autonomous self-governing body known as the Boroland Territorial Council within the state of Assam, and to provide constitutional protection under the 6th schedule to the said autonomous body. In addition to that, the objective was to fulfill the economic, educational, and linguistic aspiration and preservation of land rights, socio, cultural, and ethnic identity of the Bodos, and to speed up the infrastructure development in the BTC area. The agreement categorically mentioned as regards the status of the Boroland Territorial Council as well as the powers and functions of the District Council, which will be known as the Boroland Territorial Council. Clause 5.7 of the said agreement categorically mentioned that the office of the deputy commissioners and the superintendent of police would be outside the superintendence and control of the BTC. Clause 5.1 stipulated that the BTC shall have legislative power in respect to the subjects transferred to it as enumerated in Annexure 3 to the said agreement. A perusal of Annexure Roman 3 would show the various subjects which would be entrusted by the government of Assam to the proposed BTC, which included, amongst others, at serial number 25, land and revenue. Pursuant to this agreement memorandum of settlement, the sixth schedule to the Constitution was amended by the Constitution bracket amendment by the sixth schedule to the Constitution bracket Amendment Act 2003. At paragraph B, no, in terms with the said amendment to the sixth schedule, paragraph 3B was inserted, whereby additional powers of the Bodoland Territorial Council to make laws were stipulated. In clause Roman 15, small, of paragraph 3B, the subject, land and revenue was well within the additional powers of the Bodoland Territorial Council to make laws. Paragraph 12 of the sixth schedule to the Constitution was also amended, whereby, in addition to the words mentioned therein, inverted comma, matters specified in paragraph 3 or paragraph 3A of this schedule, inverted comma close, were substituted by the words, inverted comma, matters specified in paragraph 3 or paragraph 3 or paragraph 3 capital A or paragraph 3B of this schedule, inverted comma. In the backdrop of the above, this court finds it relevant to take note of paragraph 12 of the sixth schedule to the Constitution. insofar as the same stood amended by the Constitution Act 2003. Guya, tell me how do we reconcile it?
My lord will kindly find that in paragraph 12,
12A,
yes, 12A, my lord will kindly see at the end, 3 has been there.
where?
3. A has been introduced and 3 find place with regard to the amendment also.
Understood, but how do we read it now?
And
We have-
3A would, 12A would be applicable because 12 again starts with 3 and 4, my lord.
Application. Paragraph 12.
In paragraph 12, starting, my lord, you kindly see, these are the entries made with regard to 2003, my lord. This 12 will be applicable, my lord. 12A will come into force.
Paragraph 12. Insofar as the same is applicable to the state of Assam, reads as under. Into paragraph 12 to Bharati. Here, what we will do while making the correction,
Yes.
I've asked her to put it as per dates.
My lord.
No act of the legislative of the state in respect of any of the matters specified in paragraph 3 of this schedule. So this will be, matter will be, it will be so and so or A. I two, it under the proviso to para 3 of para 2 of the schedule. Now, in para 12, in para 1, in clause A, for the words figure specified in para 3 or 3A of the schedule. Where do you file 3A and 3A?
My lord. That would be again including 3B also, my lord.
Specified in para 3 or 3A or 3B. What is 3A?
3A, my lord, will kindly come to, my lord, this. With regard power, the district and district to make laws. Paragraph 3. A, allotment, occupation, use of setting apart of land other than any land which is reserved forest for the purpose of agriculture, so and so.
Where do you get 3A?
No, 3A additional powers of.
Not,
Not
this is
Kasar
with
Hills.
regard to not Kasar Hills. When
Yeah.
not Kasar Hills was, my lord, formed, my lord,
Karbi Anglong.
this is with regard to constitutional amendment of nineteen
Below
ninety-five.
3, Lordship.
Constitutional
Below three,
amendment act
3A is
nineteen
there.
ninety-five.
So 3, where's 3A?
3A has been incorporated, my lord, so far formation of North Kashar Hills, my lord. 3A, these are the, my lord, powers being given.
So here, these words kindly come to the constitution.
Yes,
No act of the legislature of the state of Assam in respect of any matters specified in paragraph 3 of this schedule.
yes,
Is specified in paragraph 3 of this schedule
my lord.
shall be ARB matters specified in paragraph 3 or 3A or 3B
Yes,
of this schedule.
complete, my lord.
So that has been put to, has to be put in.
Yes.
And any other changes?
Public notification, my lord.
And again there, one, again paragraph 12 has been mentioned as well. Then B, governor may by any who is so and so to which this provision of A of this paragraph do not apply shall or that state, in that
Yes,
state
so-
is amended.
Such as, my lord, in paragraph 5 is not applicable to BTC, my lord.
Where?
Paragraph 5 of the sixth schedule, my lord, is not applicable to BTC. My lord will kindly see in the insertion, well, nothing in this para shall apply to BTC council. In the constitution itself, it's been provided. That's the difference, my lord.
So we put this, but we made these changes out there
Yes.
as.
And
this-
paragraph 10 also is not applicable with regard to BTC, my lord will kindly see.
We are not
power of
concerned
district
with
council
other.
regulations.
No, we are not concerned with all these
Yes,
things.
yes.
We are only concerned with 12.
Yes.
So paragraph. You put it as it is. This court further finds it relevant. No. From the above quoted paragraph 12 of the Constitution of the sixth schedule to the Constitution of India, and more particularly in respect to the state of Assam, as applicable to the state of Assam, it would be seen, it would show that no act of the legislature of the state of Assam in respect of any of the matters specified in paragraph 3B of the schedule as matters with respect to 3A, 3A, capital 3A, and 3B. Matters with respect to which the district council or the regional council may make laws, and no act of the legislature of the state prohibiting or restricting the consumption of any non-distilled alcoholic liquor shall apply to any autonomous district or autonomous region in the state, unless in either case the district council for such district or having the jurisdiction of such region by public notification, so directs, and the district council in giving such direction respect to any act may direct that the act shall in its application to such district or region or any part thereof have effect subject to such exceptions or modifications as it thinks fit. This court finds it very relevant to take note of. A public notification which was issued is that notification you gave me last time? Or it was-
A copy.
2010.
2010, yes.
By the Principal Secretary, Bodoland Territorial Council on 28/10/2010. Taking into account its relevance, the said public notice oblique notification is reproduced here in under. Reproduce from a perusal of the above quoted public notification, it would show that the said public notification was issued in exercise of the powers under paragraph 12(1) of the sixth schedule to the Constitution. And it was further mentioned that until and unless the Bodoland Territorial Council enacts any acts, oblique rules, etc., or pending approval thereof from the Governor of Assam on bills so passed by the Bodoland Territorial Council Legislative Assembly as regards to the transferred subjects, the existing acts, oblique rules, oblique norms, oblique guidelines, etc., except the reservation of bracket posts and vacancies bracket close for SC and ST Act 1978 and the rules thereunder, and such other laws which are contradictory to the sixth schedule of the Constitution shall continue to take effect, provided that the existing acts, oblique rules, oblique norms, oblique guidelines, etc., shall in its application have effect, subject to such exceptions or modification as the council thinks fit. It is relevant to take note of that the Assam Land and Revenue Regulation 1886, in view of this uh, 1886, duly applies to the Boroland Territorial District. The question therefore arises in the above backdrop as to whether, by way of this notification to which the respondent number 4 has relied in the affidavit dated 30/12/2016, there is any conferment of power upon the respondent number 4, that is the Secretary, Revenue Department of the BTC, to exercise the appellate jurisdiction over the orders passed by the settlement officer. The Assam Land and Revenue Regulation 1886, more particularly Section 147, categorically mentions the authority to whom appeal lies. In terms with Section 147 bracket A, small a, of the regulation, an appeal shall lie to the board from the orders, original or appellate, passed by the Deputy Commissioner, settlement officer or survey officer. Under such circumstances, the question therefore arises as to, by way of this notification dated 30/12/2016, there is any amendment to the Section 147A of the regulation. Who finds it very pertinent to take note of that? Pertinent to take note of the order passed by this court on 14/7/2016, wherein instruction has been sought from the senior counsel, the senior standing counsel of the BTC, as to whether the document in the name and style of a notification dated 30/12/2016 issued by the principal secretary had been at all gazetted. This court also inquired with the learned senior counsel appearing on behalf of the BTC as to whether the notification dated 30/12/2016 can at all be said to be a public notification, which are the words used in paragraph number 12, small a, of the sixth schedule to the Constitution. The learned senior counsel appearing on behalf of the respondent, on behalf of the BTC, fairly submits on the basis of instructions that the said document styled as a notification dated 30/12/2026 have not been gazetted. 16 have not been gazetted. In addition to that, the learned senior counsel have fairly submitted that taking into account the words used by the words used in paragraph number 12 bracket a small a of the sixth schedule to the constitution, that there is a requirement of a public notification. The document, namely the notification dated so and so, cannot be said to be a public notification. This court further takes note of that the power which has been granted to the power which has been endorsed by paragraph 12 small a of the sixth schedule to the constitution upon the BTC, Boroland Territorial Council, bracket dear, the district council, is to be exercised by issuance of a public notification. If the said document, which is in the styled as notification dated 30/12/2016, cannot be said to be a public notification or have not yet been gazetted, comma, the exercise of the power, the said notification, the said document, that is the notification dated so and so, cannot be said to be an exercise of power in consonance with paragraph number 12 small a of the sixth schedule to the constitution. Accordingly, it is therefore the opinion of this court that on the basis of the said notification, the document styled as notification dated so and so, a power could not have been conferred upon the secretary of the Revenue and Disaster Management Department of the Secretary Revenue, the departmental secretary. What is the word used? Page 47. Departmental secretary of the BTC to exercise the appellate jurisdiction over an order passed by the settlement officer. The consequence, in view of the above findings or observations, it is therefore the opinion of this court that the impugned order dated so and so, the date
2025.
25/5/2023, passed by the respondent number 4, as well as the consequential order passed by the respondent number 4, immutation appeal number BTC/LR-688/2022, as well as the consequential order passed by the assistant settlement officer on the basis of the order dated 17/6/2023, cannot be sustained in law. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The notification dated so and so, the document styled as notification dated so and so, issued by the Principal Secretary Revenue and Disaster Revenue, Principal Secretary BTC, cannot be said to be a public notification in terms with paragraph 12 small a of the sixth schedule to the Constitution. And as such, the secretary, the respondent number 4, could not have exercised its appellate jurisdiction over an order passed by the settlement officer. Number 2, the order dated 25/5/2023 passed by the respondent number 4 is set aside and quashed. Number 3, The order dated 17/6/2023, which is a consequential order to the order dated 25/5/2023, passed by the order dated 17, passed by the ASO, it's a Eastern Settlement Officer, which is a consequential order to the order dated 25/5/2023, cannot also be sustained in law, for which the same is set aside and quashed. Next. This court duly takes note of that on the basis of the document styled as notification number dated so and so, the respondent number 7 and 8 have prepared an appeal before the respondent number 4. Seven and the private respondents, the private respondent, that is respondent number 7 and the respondent numbers 8A to 8D, have prepared an appeal before the respondent number 4. As the respondent number 7 as well as the private respondent number 7 and respondent numbers 8A to 8D have approached the respondent number 4 bona fidely, assuming that the respondent number 4 had the jurisdiction. It is the opinion of this court that the respondent number 4 should be granted an opportunity to prepare an appeal before the Assam Board of Revenue in terms with section 147 small a of the Assam Land and Revenue Regulation 1886. It is therefore observed and directed that in the circumstance the respondent number 7 as well as the respondent numbers 8A to 8D prepares an appeal against the order dated
Chapter 3. Page 27.
27/2022, passed in Miss Case number 2/2022, within a period of how many days? 30 days. Mr. Das, your thing.
Lordship, I put respond number 7, your lordship.
That is what I'm saying.
Lordship.
Are you not aware what am I dictating?
Lordship, in that.
You don't want the right to filing an appeal.
Lordship, obviously, lordship, I'll be
30 days, my
approaching the board.
You
of
don't
revenue,
know.
your lordship. I'll be approaching the board, your lordship,
So that is what, how much they need
30
to
days.
require?
30 days, maybe 60 days, lordship, I have to communicate with the
15 days because of your conduct.
lordship, let it be 30 days, your lordship.
Uh,
I was
because
going through the order, your
Mr.
lordship.
HRA Ahmed, you are there?
Yes, madam.
Okay, remove his name there. No. HRA Ahmed. Granted 30 days for preparing an appeal against the order dated so and so. If I filed within a period of 30 days from today, the learned Assam Board of Revenue shall decide the say appeal on its merit without insisting on the question of limitation. This court, for the sake of clarity, observes that the observations so made in respect to the document styled as notification dated so and so, holding inter alia that the respondent number, holding inter alia that the secretary revenue that the respondent number 4, that is secretary revenue, land revenue and disaster management department, isn't it? This is the name of the respondent number 4.
Lordship, page 34, Secretary, Land Revenue and DM Department, Boroland Territorial Council.
and so.
Kokrajhar.
Shall not affect any adjudication so carried out by the respondent number 4 prior to the passing of the instant order and those issues which have, and thereupon the said issues have already been settled. This court, however, further observes that the instant judgment so passed shall not affect the rights of the BTC to exercise powers in terms with paragraph 12A of the 6th schedule to the Constitution, the manner stipulated therein.
Deeply applied.
Lordship, there are some corrections. 12A, Lordship, instead of 12A, it would be 12(1)A, Lordship.
Well, one A.
And there is a Lordship has granted liberty to respondent number 4 to approach the revenue board, Lordship. Lastly, your Lordship
I
has.
never give it. I gave it to 7 and to the private
Seven.
respondent 7 and 8A to 8D.
Lordship, lastly, and as per instructions sought for from my senior learned friend, your Lordship has dictated that 14/7/2016. That would be 2020. Lordship.
You see, these things they will correct it. Don't worry about.
Obliged.
Much
I
obliged.
closed.
Lordship, all consequent orders. Lordship has mentioned only one consequent order. The all consequent action by the respondent authority. Have
No,
no.
there are, you have challenged only these two orders.
Lordship, thereafter, we have heard that they are going to
Patta also
issue
created.
patta, Lordship.
Patta also created in the name of respondent number 7, my lord.
Yes.
Case 83, my lord, I have annexed.
You have not challenged that.
No, Lordship, I have
Subsequently.
challenged, Lordship, as subsequent.
He to be- And so, as well as all consequential orders based upon the order dated 25/5.
Lordship, obliged.
May I please,
Yes.
your lordship? While we go through the record, my lord, we found some mistake in DAG number 5. May I submit, my lord? DAG number 5, that with regard to DAG number 5, there are some error, my lord. May I submit, my lord? My lord, kindly see. That is the additional affidavit filed by the petitioner in page number. Yes, my page number 91, my lord. 91 in 1973. This is in Assamese. May I read, my lord? 1973-74 চনৰ 81 নং পাত্তাৰ 20/9/74 হুকুম মতে উত্তৰ থেকে সূত্ৰে এই পাত্তাৰ সমুদায় মাটিত পাত্তাদাৰৰ স্থলত শ্ৰী DB Nicholson Lloyd, L Nicholson Roy and Vidya Nicholson. Here the petitioner is Vidya Nicholson Roy. They are the legal heir of the Vidya Nicholson Roy, my lord. নামত নামজাৰি কৰা হল. This is the order of 73-74. But kindly see, this is the original DAG number. 31 is the original DAG number of DAG number 6, my lord. And in this Damabandi, my lord, DAG number 6, there is a DAG in patta number 6, DAG number 5, 45, 46, all are there, my lord. That is not the creative DAG of the DAG number 5. And DAG number 5 in 1974 itself is a Sat DAG, my lord. There is a cross mark in the DAG number 5 in the Zamabandi of
You
73-74.
have made it very clear that this land belongs.
Yes. No, my lord, that is,
No,
my
I
lord,
am
while
not-
I'm going through the for
No,
this
no, no,
purpose
don't
only, my
bring
lord.
up all these issues.
Yes, my
Don't
lord.
rake up here. All these issues have been. My question is, what is your,
My lord, but
you have no nothing?
nothing, my
You
lord.
pass the final.
Yes. But my this submission may be recorded.
No,
my lord.
not reported. You said, well, you should have challenged that order earlier. You have not challenged those orders. But they're very. So therefore, you direct here, this land has been demarcated to that effect. I give you 3 months because of either acquiring or hand over the position.
Yes.
No, you are not purchasing. So we direct you that your instruction is nothing to that effect. So you do. We propose it up in that. Makes no sense keeping.
Of this 2013 Supreme Court, my lord. In this type of cases, my lord. Some directions were given, page 22, months, para 22.
don't think this is required. They'll hand over the land to you.
If they hands over the land, my lord, suppose the portion of the land which they will hand over, now there exist some structures which are not,
You take over they will give you a vacant possession.
yes, that lordship, because
be.
otherwise, my lord, if that plot of land
10
with,
days you hand over the possession.
yes, plot of land with buildings and all those things are given over, then my lord,
15 days.
again,
Heard Mr. Adas, the learned counsel appearing on behalf of Mr. Miss A. Gayan appears on behalf of the respondent numbers 1 and 2. So and so appears for
3.
Mr. J. Hendig appears for the respondent.
4 and 5.
The present petition been filed by the petitioner. Claiming, seeking appropriate directions on the respondent number 2 to vacate. Present petition has been filed by the petitioner, espousing his constitutional rights, his or her, our petitioner there,
Yeah.
their constitutional rights under Article 300A of the Constitution, inasmuch as it is the case of the petitioners that respondent number 2 has been in illegal and unauthorized occupation of the petitioner's land. Therefore, the possession of the said land be handed over to the petitioners, and also pay due compensation on account of the use of the petitioner's land since the year 1975. The petitioners alternatively have also prayed that in lieu of the buildings, in view of the land to be handed over, the respondent number 1 and 2 may acquire the land of the petitioners, and by paying due compensation as per law. Brief facts of the case. The petitioners herein are daughters of late Vidya Brumbach, bracket, and Nee Nicholas Roy oblique Vidya Nicholas Roy. The petitioners jointly inherited 50 bighas of land comprised in DAG number 5, 44, 45, 46, 49, 50, 51, 55, take your seat, 56, 58, 79, 80 oblique 145, 83 and 85 and 86 of Patta number 31, situated at village Urutari under Moza Hunapur in the district of Kamrup, Assam. Kamrup Metro, na?
Metro.
Kamrup Metro, Assam. It is the case of the petitioner that land measuring 5 bighas 4 lechas covered by dag number 5/49 along with other probable dags of patta number 31 has been in forceful occupation of the respondent number 2 since 1975. Wherein the respondent number 2 have constructed their water pump house for facilitating supply of water to the group center CRPF. It is the further case of the petitioners that their attorney approached the respondent number 2 on various occasions to vacate the aforesaid land over the peaceful vacant possession. However, the respondent number 2 not have turned a deaf ear to the requests made by the attorney of the petitioners. Resultantly, the petitioners have issued a legal notice dated 27/12/2004 to the respondent number 2 with a request for immediate vacation and handing over the vacant peaceful possession of the land in question to the petitioner, or to initiate acquisition proceedings for payment of the appropriate compensation to the petitioners in accordance with law. The respondent number 2 had replied to the notice of the petitioners by the letter dated 10/1/2025, welcoming the petitioners to discuss the aforesaid matter with valid documents. The petitioner thereupon However, no discussion was carried out with the attorney of the petitioners. The petitioner thereupon submitted a representation before the Deputy Commissioner Revenue, Deputy Commissioner Kamrup Metro, on 16/5/2012. Pursuant to the said representation so submitted, the Deputy Commissioner Kamrup Metro issued a letter dated 21/6/2012 to the Circle Officer, Honapur Revenue Circle, to conduct a joint verification of the land in question on 28/6/2012, which is under the possession of the respondent number 2, and submit a report. The respondent number 5 conducted a spot verification, and on 1/9/2012, carried out a spot verification on 1/9/2012 and found that the respondent number 2 have been occupying an area of 5 bighas 4 kathas under dag number 5/49 of patta number 31 of the petitioners for water pump house. And accordingly, by letter dated 7/12/2012, issued to the respondent number 2 to appear and submit necessary documents pertaining to the aforesaid land in question on or before 15/9/2012. On 15/9/2012, the respondent number 2 took time to use necessary documents. It was only on 8/11/2012 the respondent number 2 submitted one document, that is a certificate of land handover to the parties, and the letter dated 8/11/2002 issued by the respondent number 5 had mentioned the matter was already taken up by the then Deputy Commissioner, Kamrup, for providing acquisition of order and patta, but no document have yet been issued yet. Really. So and so spot. So, I don't know. So document ওখানে খুঁজিলে dated 7/9/2012. You right? 11/2012, the respondent number 2 document that is certificate of land holdover to the parties. Issued by the four. Who had issued this?
Handing and taking over.
8/11,
Handing and taking handed over.
where is the document?
Yes.
35A is the type.
Huh?
Is 36. 35A is the type.
SKR Sonapur Circle. Handed over, my lord.
Land handover document by the Tatar Kanangu Revenue, Funapur Revenue Circle. The group, they will DYSP, Group Center, CRPF. The said document has been enclosed as annexure Roman 8 to the writ petition. A perusal of the said document clearly shows the land which was handed over possession of KP lands measuring biga iman of Sarkar. How much land has been given?
14 bigha, 1 kata, 5
Of
letter.
which 10 bigas were Hirat Patta.
Yes, madam. And Sorutari. And 2 bigha, 2 kata, 10 letters of village, Sorutari. All total land measuring 14 bigha, 1 kata.
Well, understood, of which 10 bigas were KP land.
Yes, ma'am.
Means it has
In
land measuring 10 bigas, 1 kata, 12 lichas.
the Sarkari land, madam, 10 bigha.
No, that is KP Pattalam, 10 big.
What is the language used? Possession of heat. Bigas so and so of Sarkari land. Sarkari land measuring means 10 bigas are private lands. 1 biga is Sarkari. So 1 biga, 2 bigas is Sarkari. That 14 bigas, 1 kata, 5 lechas were handed over. Pursuant to acquisition being carried out. Out of which 10 bigas, 1 kata, 12 lechas where private lands which have been acquired and the remaining lands, that is 1 biga, 2 katha, 3 lechas, and 2 bigas, 2 kathas, where government lands. Records further reveal that respondent number 5 thereupon submitted an inquiry report on 21/11/2012. Wherein it is categorically mentioned that though the respondent number 2 had claimed that the land was handed over on the basis of certain acquisition, but as per the revenue records available in the office, there is no record of any order of acquisition or compensation of the said land used as water pumping house oblique station by the CRPF situated at village Horutari, initiated or paid to the original patta holders. That is, number 1, Charline Nicholas Roy. Number 2, Krisanda Nicholas Roy. Number 3, Cellist Nicholas Roy. Namkita, page 38. The records further reveal that on 15th of October 2012, a communication was issued by the DIGP, CRPF Gauhati, to the Deputy Commissioner, wherein it was intimated that 14 bigas 1 katha 5 lechas of land were acquired under acquisition order number Karachi 6-15 of the 7 for the purpose of Group Center CRPF at Khanapara. But unfortunately, the said acquisition order and patta is not available in the record. The Deputy Commissioner was therefore requested to provide the acquisition order and patta. The records further revealed that various joint verifications were carried out, and the respondent number 2 could not produce any document of any acquisition. In spite of that, the respondent number 2 did not vacate the land, and it is under such circumstances the petitioner had approached this court, filing the present writ petition. The records reveal that this court, by an order dated 9/5/2014, issued notice the respondent number 2, 1 and 2 have jointly filed an affidavit in opposition Let me come back. Oh, take out that other judgment. Vidya Devi is there, one. I think that will be enough. Devi judgment is. Then 15 days to begin. This has already been demarcated, so we make it very clear. Two have filed their affidavit, Very. They raised the issue as regards the maintainability of the writ petition. On the ground of availability of the statutory remedies. It was the case set up by the respondent numbers 1 and 2 in their affidavit in opposition. That 14 bighas, 1 kata, 5 letters of land was handed over. After having been acquired under acquisition order number Karachi 6-15/74 dated 31/3/75 for the purpose of setting up of the group center CRPF. 4/4/1975. Since then, the land under the occupation, possession and occupation of the CRPF. It was further mentioned that documents pertaining to the acquisition proceedings were not available with the respondent number 1 and 2, for which various requests have been made to the Deputy Commissioner Kamrup. In addition to that, on the basis of the certificate of possession, the respondent authorities, the respondent number 1 and 2, claim rights over the land. They've also set up a plea of adverse possession on the ground that they have been physically, continuously, overtly, and hostilely possession over the land. Records reveal that an affidavit in opposition was filed by the respondent number 4 on 12th of January 2016. wherein it was categorically mentioned that document could be no document as regards the acquisition of in regards 1 kata 5 lakh. Petitioners have also filed an affidavit this court finds it now necessary to take note of the various orders which have been passed by this court since 24/9/2024. The learned coordinate bench by an order dated 24/9/2024 wherein the learned coordinate bench has observed that in view of the stand so taken by the petitioner along with the state respondents, the option that may lie with this court was subject to the materials that may be produced by the respondent number 2. They direct the respondent number 2 to acquire the land and pay the rental compensation since the date of their possession. The respondent number 1 and 2, counsel for the respondent number 1 and 2 took time for filing a reply. On 17/12/2024, when the writ petition was taken up, which is almost after 10 years from the filing of the present writ petition, an additional chance was provided to the respondents to produce any document to show that the land of the petitioner in Dag number 5, Pata number 31, 30, taken over by following the due process. Nothing in that regard could be produced. Authorities. This court finds it relevant to take note of the order dated 21/8/2025. Report of the Circle Officer Hunapur Revenue Circle was placed A perusal of the said report, it was clear that the land in respect of which the petitioners herein instituted the proceedings initiate at measuring 6 bighas 1 acre is covered by DAG number 5. Is under the occupation of the CRPF. It was further mentioned that in the said report that along with the map enclosed as Annexure Roman 5, that the original DAG number 5 had 14 bighas 1 katha 7 lechas. The said DAG number 5 was thereupon partitioned into various DAGs, of which DAG number 49 was created at measuring 3 bighas 2 katha 9 lechas, and the remaining area in DAG number 5 is 1 bigha 2 katha 15 lechas. This court categorically observed in view of the said report, thereby granting an opportunity to the respondent number 2 to take a decision as whether they would like to retain the land at measuring 6 bighas 1 katha 8 lechas, which belongs to the petitioner and under the occupation of the respondent number 2 by carrying out acquisition in accordance with law, or they would like to hand over the possession of the land back to the petitioners. On 23/10/2025, the Learned Council, Learned CCC, Ms. A. Gayan had submitted that pursuant to the demarcation proceedings, the respondent number 2 was aware of the fact that the respondent number 2 was in a occupation of the land belonging to the petitioners. However, on account of ascertaining how much land the respondent number 2 would like to keep and how much land the respondent number 2 would like to acquire, they have contacted the concerned circle officer, and the circle officer had given time on 7/11/2025. The record reveals that an affidavit thereupon was filed by the respondent number 2, wherein the respondent number 2 have duly admitted that a part of DAG number 5, as it originally stood, is under their possession, and therefore they have written a letter to the concerned circle officer to indicate the said portion specifically so that they can take a decision which part of the land they would like to relinquish and which part of the land they would like to retain by acquisition. This aspect was duly noted in the order dated 4/11/2000. On 11/11/2025, this court passed certain directions which, being relevant, this court reproduces the order dated 11/11/2025. On 12/3/2026, was taken up. A discrepancy was pointed the discrepancy which was pointed out in the map which was produced by the circle officer And on the basis thereof, this court posed the question upon the respondent number 2. Posed the question upon the circle officer, Unapur Revenue Circle, to provide instructions insofar as the discrepancy said discrepancy was corrected and a clear picture was placed before this court, which is duly recorded in the order dated 2/4/2026. And accordingly, on the same date, Ms. A. Gayan, the learned CGC, submitted that the proposal would be sent to the Director General of the CRPF for according the necessary sanction pertaining to the land, which the CRPF would like to retain by carrying out the necessary acquisition, as well as the portion of land which the CRPF would like to give up. Thereupon, the matter was listed on 21/5/2026 and 9/6/2026, when the learned CGC apprised this court that the question as regards acquisition was pending before the Director General, CRPF. And further, the Ministry of Home Affairs has also to be taken into consideration. And accordingly, this court fixed the matter today with a categorical observation that if substantial progress is not shown before this court on the next date, this court shall take up the instant proceedings for final disposal. Today, when the matter is being taken up, Ms. Aga and the learned CGC submitted that the respondents number 1 and 2 are not inclined to carry out any acquisition, and that they would continue to remain in possession of the land. The backdrop of the above, this court took up the present petition. In view of the said submission, this court have therefore taken up the present writ proceedings for final disposal. Mr. Adas, the learned counsel appearing on behalf of the petitioner, submitted that the materials on record would clearly show that it is the petitioners who are the owners of the land in question. And therefore, the respondent number 2 do not have the right to remain in occupation of the land, as it would violate the petitioner in violation of the petitioner's rights under Article 300A of the Constitution. Mr. Adas, the learned counsel, submitted that for the last 12 years, for the last so many years, prior to the filing of the writ petition, as well as even after 12 years from the date of filing of the writ petition. The respondents have not been able to place any document to show that the petitioner's land have been acquired. The learned counsel further submitted that the respondents number 1 and 2 have been taking their stand as per their own convenience. Sometimes they duly admit that they have no right over the land under occupation, more particularly the tag number 5. And submits before the court that they are taking steps for the purpose of acquisition. On the other hand, the petitioner, the respondent number 1 and 2, again questions the rights of the petitioner, mainly on the basis of a possession certificate issued by a Sardar Kanongo in the year 1975, without there being any contemporaneous materials to show that there has been any acquisition of the land under, in terms with the provisions of law. The respondent number 2 cannot be granted, cannot be permitted to use the land of the petitioner use and occupy the land of the petitioner in violation to the mandate of Article 300A of the Constitution. In that regard, the learned counsel for the petitioner referred to the judgment of the Supreme Court in the case of Tukaram Kanna Joshi and others versus Maharashtra Industrial Development Corporation and others, reported in 2013, 1 SEC 353. And
Regard that Vidya Devi, that no adverse possession.
there's another judgment of Justice Dalbir Bhandari, wherein it categorically says, I don't think Vidya Devi doesn't say so.
This Vidya Devi says, my lord, this adverse possession will not come. The state is in illegal possession, my lord.
As well as the judgment of the, as well as the judgment in the rendered by the Supreme Court in the case of Vidya Devi versus State of Himachal, quoted in 2020, 2 SEC 569. Per contra, Ms. Ada, Again, the learned submits that the dispute in question, civil dispute, and as such, this court may not like to exercise the jurisdiction. The 2 to 6 of the Constitution Now, which document you are referring to?
Number 91, my lord.
Well, see, come further, referring to the copy of the Jamabandi submitted. Where?
Submitted. Submitted by the affidavit in opposition by the circle officer, my lord.
Submitted where?
কেতিয়া কৰিছিলে?
April 25, my lord. It was served to us on 23rd of April 25.
Huh?
It was served to us on 23rd of April 25.
That's okay. Page 91, I've got it. Which document?
Document, my lord, 90, R2, my lord, 91, my lord, in the first line, my lord. Patta number 6, dag number 5, chart dag.
Where?
The first line of this Jamabandi, my lord, first line, Reverend JJM.
Column
number-
4, she is referring to column,
Huh?
column 4.
Column
my lord.
4,
On top, it is written in
the
vernacular.
top, yes, vernacular, my lord.
Sat.
Orup Burman on top.
No, on top, this is a Reverend JJM.
Huh?
This is my
This
point.
page, yeah, page,
91.
page 91, number 4, just below 4 is chart.
Referring to, this is an affidavit of
Affidavit of circle officer, my lord. কেতিয়া কৰিছিলে? 23rd.
not a part of it. Affidavit, circle officer's affidavit dated?
23/4.
Okay, what is this document?
91, my lord.
Ah.
Reverend JJ, my lord, first line, the name of the Patadar is Reverend, then my lord, in column 4, dag number 5, my lord. That is Sat, my lord.
Ah.
And this is the cross mark, my lord, in chart dag.
Ah.
And then in column 1, 2, 3,
Om
4,
Sarkaror so and so Tarikhor. Tag number 6.
yes, dag number 6, or is it the original dag number of 30?
Huh?
That is the original dag number 6, my lord.
Patta number 6.
Sorry, my lord, patta number 6, sorry.
Dag number 5.
Dag number 5, my lord.
The order of the year. Refer to another one. You are saying about this document
Yes, my
of
lord.
1975.
1975, my lord.
Does it say?
Yes, my lord. In column number 10, my lord. 1973-74 চনৰ 81 নং 20 ন 74 চনৰ হুকুম মতে উত্তৰাধিকাৰী সূত্ৰে পাত্ৰাৰ সমুদায় মাটিত পাত্ৰাদাৰৰ স্থলত শ্ৰী সোণাল বিবি নিকলসন লয় আল নিকলসন লয় এণ্ড শ্ৰীমতী বিদ্যা নিকলসন লয়ৰ নামত নামজাৰি কৰা হয়।
Name of?
Vidya is the mother of this the petitioner, my lord.
Then?
And my lord, in that time, that is the order of 73-74, my lord.
Ah.
In that time, the dag number 5 is there, and that dag was the Sat dag, my lord. That is reflected in up, my lord.
What
Chart,
dag?
chart, CHAT, chart. Common land, my lord. Finally, see in my lord, column
Document
number
you are referring to.
column number 4, my lord.
21.
If you did, okay, ito mo po.
No, what do you say about page?
My lord,
Let's see page 88.
88, my lord. Yes, my lord. Is 88.
What do you say?
Quantum of affirmative action.
Now, what does it say? I don't understand.
That has been mutated
What
in
is-
the name of
That
in
means
70 in 74, my lord, that whole land of dag number sorry patta number 6 was recorded in the name of mother of the petitioners, my lord.
And
But at that point of time, Dag number 5, Dag number 5 and 49 was there, my lord, in the Jamabandi copy. And Dag number 5 is, there is a, they drawn one cross mark in Dag number 5. And Dag number 5 is a Sat Dag, my lord, according to the record.
what is Satdag?
Chart, my lord, as per my knowledge, my lord, chart is the government land, my lord.
What?
But like, kindly see, 5 and 9 is the government land. In also, they recorded in page number 88, my lord. Page number 88, my lord. Come to page number 88, my lord.
What do they say?
Here also, my lord, kindly see column number 10, my lord.
Read that. Ahom
অসম
Sarkar.
চৰকাৰৰ 24/9/72 চনৰ জাননী মৰ্মে অতিৰিক্ত উপায়ুক্তৰ 28/10/72 RR কাৰাচি 6/234/3 নং চিঠিৰ আৰু উপসমাহৰ 11/11/72 তাৰিখৰ প্ৰাপ্তি 681 নং চিঠিৰ হুকুম মতে 6 নং পাতা 9 নং দাগৰ 262 বিঘা 1 কঠা চাম লেচা জমি চিলিং আইন মতে 13
How is this relevant ceiling
Because
act? This
that
is,
is not
this
relevant.
goes as for the fixation of ceiling act.
That is not relevant, but 91 is relevant. But
Why are you saying 91 is relevant? Don't get it.
relevant
Because
because 73, 74, their name has been mutated in the name of the mother of the petitioner, my lord.
Ah.
Yet the name of the mother of the petitioner, her name had been recorded on 73, 74.
no. See, this particular land originally belonged to this Hunapur estate or something to that effect, isn't it?
So originally, my lord, it belonged to the predecessor in interest of the.
This was a tea state.
Yes.
From this tea state, because of that, it has gone on ceiling
Yes.
under the fixation of ceiling act. In 1974-75, the fixation of ceiling acts happened. And therefore, these 263 vigas were taken over as bad debt.
Tag number 9, my lord.
And that is how, what is the dag which was taken over?
Tag number 9, my lord. I think.
What?
As per as per page number 88, my lord.
Well, what is the dag
260.
number which was taken over?
62 বিঘা, my lord. That is tag number
Umar mote
6 নং পাতাৰ 9 নং দাগৰ।
9 number dagor iman matile. So it has been taken from dag number 9. How are you concerned with that? Dag number 9. We are only concerned with dag number 5. And how are you concerned whether 5 became a part of the fixation of land?
So that is, my lord, as per their record, my lord, this is a chart dag, my lord.
What is Sat? I've never heard of that Sat.
Kindly, in the Jamabandi also,
What is Sat?
in that page number 90 also, it was written chart, my lord.
Oh, no, what do you mean by Sat?
For my
You must be backed with some legal document.
that is not the land of the that is not the
Absolutely.
patta land.
No, their names are there.
That is not the patta land as per my knowledge, but I don't know whether I am right or wrong,
No,
my
they
lord.
kindly read of page 91. Read it.
Yes, my lord. Their name has been recorded entered the patta number 6, my lord, except tag number 5 and 9, my lord.
9 is out.
9 is out, 5 also.
9
my
is
lord.
out, you see. 9 is out. But the other here, dag number 5.
5 is also out, my lord.
No,
but,
5 is not out.
But there is a
No, 5 is there. And from there you have various other dags. You see, all these small dags came in, which is 14 bigas, 3 katha, 7. How much lesser is this? Initially, the land was much more. Initially, the land was 196.6, 26 R. Now, this is R. R.
14 bigger.
So there it is. So here, but the next one, the dag number 9 goes, 22 remains, 32 remains, 33 remains, 5 remains. 5 remains. Then you see page 92, what is written here. See the, now see, as per the area of the additional deputy commissioner, so and so for complete part area, so therefore this 5 becomes so many dags. 5 was 5 divided into these 14 bighas was divided into all these dags. Heard of.
That document which your lordship has marked as Z. Tag number 5 is there. Patta, I have brought it on record by.
Yes,
in the
Patta is there, everything
Patta
is
is
there.
also there. Then how can it be? And if they ought to have disputed way back in 20.
Submitted. Mr. Ms. So-and-so, the learned counsel submitted. Referring to affidavit filed by the respondent number 5 on 4/2025, and more particularly to the Jamabandi, which has been enclosed as annexure R3 and submitted that the said Jamabandi shows that Dag number 5 is a government land on the basis of a remark being put as Sat.
Yes, ma'am. That is also mentioned in page number 90 also, madam. Type copy. CG.
Annexure R2 R. Into annex.
Yes, sir.
What do you mean by Sat? I've never come across that term.
Let me take
The instruction out there. I've never come across this term Sat. Right. In other words, it is the case of the respondent number 2, 1 and 2 as per the submission. That the petitioner have no right over Dag number 5 or the partition Dags which have been formed pursuant to or the partition Dags or the subdivided Dags, which were Dag numbers 44, 45, 46, 49, 50, 51, 55, 6 and 58. This court have heard the learned counsels and this court have also heard Mr. J. Hendig, the learned counsel appearing on behalf of the respondent number 4 and 5. Who duly submitted on the basis of the pleadings so filed as well as the reports so submitted before this court. Mr. J. Hendig, the learned counsel submitted that from the materials on record, it is clear, it is apparent that the Dag number 5 well as Dag number 49, which is the subject matter of the present proceeding, is under the possession of the respondent number 2. Further submitted that DAG number 5 initially. Yes.
Lordship, that means Lordship, my lord, if there is a two dark number, the land owner is my lord, one person. But when my lord, he was asked to the approach to the my lord, concerned authority, they said that there are these dark are same my dark, my land. So I want to one dark number. So when it is the merge with the one dark number, it is called Lordship sat.
Again, tell me, I've never heard of this.
Lordship, two dark numbers,
Ah.
one person, Lordship. He is the whole,
So two DAG numbers are
in the same class, Lordship.
both the DAG numbers are then instead of being bifurcated normally, which is there, both are brought together.
Together. And it is called a sat, Lordship. There's no other dark number, other is there, other part, numbers is there, Lordship.
So it solely belongs to it.
Lordship. This means, my lord, that if it is sat, there is no any, my lord, land is there, Lordship. In other, Lordship, the partition or other dark numbers. So it is marked with the one dark numbers only.
So
If it is
here,
March
here
Lordship,
if
it
we
is-
see the SAT which is being mentioned out there,
Lordship.
5, and there are various other DAGs. So all these DAGs combine and becomes 5.
That's why it is said.
Or in other words, one can very say that these 5 DAG numbers or 10 DAG numbers become a part of 5. Seriously, I've never heard that Sorkari, otherwise they will put a Sorkari. The Learned Council further submitted that the acquisition which is being referred to by the respondent number 1 and 2 in the affidavit could not be traced out. Therefore, if you see page 99 or page 87, Mr. Hendrik, page 87, if you look into it,
But I have some.
actually it means 5 is the DAG.
Lordship.
Therefore, you put it in the middle.
Lordship. Then
That DAG already contains 1 bigha. But the other DAGs which are there, I think the word SAT is being mentioned this to show that it has been formed from these DAG,
This.
5. That is why.
that's
Normally what happens, you put a round.
Lordship.
When a partition happens, you put a round. And so the new DAG.
Hmm.
The moment you put a round in the ear, the Jamabandi,
Lordship.
it is seen that this particular DAG no longer remains. And it has been then bifurcated or partitioned into
Partitioned.
small DAGs. But if the original DAG remains, that means some portion of the DAG is remain, then you put the word SAT
Sat.
to indicate that this particular, from these DAG, the other DAGs have been formed. But the original DAG still remains because some land is there somewhere. I think that is the meaning of SAT. And therefore, while taking out the year, you put 5 separately from the others.
Lordship.
You put the 5, na,
Five,
separately.
Lordship.
You could have put the 5. If you see page 988, you have put the 5 or page 100, which is given to me.
Lordship.
You put the 5 separately from the others. Means the 5 remains because there is some land somewhere
Lordship.
and the others are part of 5. And therefore you use
After
the word
partition.
sub. This court have heard the learned counsels on the basis of their respective submissions. First, have the heard the learned counsels appearing on behalf of the parties and have also taken account, taken note of the various submissions so made as the respective pleadings, and more particularly the various reports so submitted by the respondent number 5. From the documents, it is apparently clear that the respondent number 2 is in possession of the land covered by DAG number 5, as well as DAG number 49, wherein patta has been issued in favor of the petitioner. The record of rights also clearly show that the petitioner name have been duly mentioned in the said land. There is no quarrel with the proposition that the patta which have been issued to the petitioners is a document of title. On the other hand, the respondent number 2 have not been able to show, even after a passage of more than 12 years, that the land of the petitioners were at all acquired, and on the basis of which the land vested upon the state, land was handed over to the respondent number 2. This court also takes note of that in the record of rights there is no mention at all that at any point of time any acquisition was carried over in respect of the original DAG number 5 or the subdivided DAGs from original DAG number 5. It shocks and surprises to the court to take note of the document on which the respondent number 2 have relied upon. That is the document of handing over of possession. This document do not show in any manner as regards what government DAGs were transferred to their names, to the what was the number of the government DAGs, or the patta land which was wherein possession was granted to the respondent number 2. The said document appears to be completely vague. The respondent number 2 had claimed that the land had been acquired. Nothing has been placed before this court to show that any money was paid by the respondent number 2 at the time of acquisition. The stand which had been taken by the respondent, the state authorities, also makes it clear that the land in question belongs to the petitioners. Various opportunities were granted to the respondent number 2 to take steps for acquisition. However, the respondent number 2 however, today it is being submitted that the respondent number 2 is not inclined to acquire the land in question. Under such circumstances, it is therefore the opinion of this court. Now, full stop. In this perspective, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Vidya Devi Supra. When the Supreme Court in uncategorical terms have observed that there are constitutional rights under Article 300A of the Constitution is a human right. And such power to take over the lands by the state to be in consonance with the provisions of Article 300A of the Constitution. In the instant case, the petitioners here, the respondents herein have taken a plea that they have been residing they have been in occupation of the lands from 1975 onwards. And the petitioners have only initiated the proceedings sometime in the year 2005. In the case of Vidya Devi, there was a delay of 42 years. Then also the Supreme Court held that the state cannot be permitted to usurp the rights of the individual. It was also mentioned that the state cannot also be permitted to take the plea of adverse possession. Thereby, to grab the property of its own citizens. This court also finds it relevant to take note of the judgment of the Supreme Court in the case of Tukaram Joshi Supra. Wherein, at paragraph number 17, the Supreme Court categorically observed. Paragraphs number 12.1 12.2, 12.7, 12.8, 12.9, 12.10, 12.11, 12.12, and 12.13 being relevant is reproduced here in under. This court now finds it relevant to take note of the judgment of the Supreme Court in the case of Tukaram Joshi Supra, wherein the Supreme Court, at paragraph number 17, categorically observed that depriving the citizens of their immovable property was a clear violation of Article 21 of the Constitution. In a welfare state, the statutory authorities are bound not only to pay adequate compensation, but there is also a legal obligation upon them to rehabilitate such persons. At paragraph number 18, the Supreme Court further observes that the appellants therein were deprived of their legitimate dues for about half a century. And accordingly, passed specific directions at paragraph number 22. First, this court have also taken note, paragraph number 17, 18, and 22 being relevant are reproduced here in under. This court have also taken note of that in both the judgments in the case of Tukaram Joshi Supra as well as Vidya Devi Supra, the Supreme Court had made it clear, had directed acquisition of the land. But however, in the instant case, the respondent number 2 have categorically made a submission that they don't want to acquire the land. Under such circumstances, it is therefore the opinion of this court that the respondent number 2 cannot be permitted to further continue with their illegal occupation over the land, more particularly dark number 5 and dark number 49 of Pata number 31. Pata number 31, na? Of so and so, village so and so. Village to Sailu, huh? Village so and so. This court is also of the opinion that there has to be an adequate compensation paid by the respondent number 2 to the petitioner on the basis of the illegal occupation of the land. Accordingly, the writ petition stands disposed of with the following directions and observations and directions. The respondent number 2 has no right to remain in possession over the land at measuring 5 bighas, 0 katha, 4 lechas, isn't it? Covered by dark number 5, bracket of dibo, 1 bigha. What is that 5?
1 bigha, 2 kata, 15 lechas.
15 lechas.
And
Dark number 49
3 bigha, 2 kata, 9 lechas.
of Pata number
31.
so and so. Of a village so and so. The said lands have been clearly and categorically identified, as would be seen from the various demarcation reports. First, the respondent number 2 is aware of the area. First, accordingly, this court therefore directs the respondent number 2 to vacate the land covered by dark number so and so, itu Kiman Lane, and 49 Kiman Lane of Pata number so and so. Within 30 days from the date of passing of the present judgment. Taking into account that for the purpose of further, in order that there is no such dispute in future as regards the area, this court further directs that at the time of handing over the possession of the land by the respondent number 2 to the attorney of the petitioner,
Attorney
And,
to the
attorney,
petitioner, the attorney
to the
has-
petitioners.
or his attorney, madam.
attorney is not here.
There's some other attorney, because if they are staying at UAS, my lord, if they are not able to come, they will engage some attorney.
Petitioner or his their duly authorized representative. The circle officer of Hunapur Revenue Circle shall be present. Number 3. Taking into account, what about the compensation? Insofar as the compensation for the purpose of illegal possession of the land in question this court is of the opinion that a compensation amount payable to the petitioner has to be taken from the date of filing of the instant writ petition. Accordingly, this court directs the deputy commissioner, Kamrup, na? Kamrup, to make assessment of the compensation payable to the petitioner in terms with the provisions of section 11(4) of the Assam Land Requisition and Acquisition Act 1964, and on the basis thereof, from the date of, with effect from 6/5/2014, with effect from 11/4/2014, 11/4/2014 till date, and thereupon submit the same to the respondent number 2. The respondent number 2, on the basis of the said compensation assessed shall make payment to the petitioner if shall make payment to the petitioner or seek reference in terms with section 12 of the AACON, Assam Land Insurance. The said reference, if sought for, no, itu no. I've said reference no, yeah. Shall make the year and submit it to year. The said amount be paid to the petitioner within 60 days from the date of communication of the assessment by the Deputy Commissioner, Kamrup Metro, to the respondent number 2. It is made clear that if the respondent number 2 is not agreeable to the, is aggrieved by the amount of compensation adjudged, the respondent number 2 would be at liberty to assail the same in accordance with law. Anything more?
My lord, the respondent number 2 will determine it within a time period, my lord. The respondent number 2, my lord, will determine the compensation amount within a time period, my lord.
Number 2, that will
Sorry, my deputy commissioner.
So within 2 months. Within 2 months, and intimate to them, and
Then-
they would then make the payment within 2 months thereafter. And if you are aggrieved, you can challenge them.
Regarding the, my lord, possession, they will hand over the land, my lord, in a without any structures or anything.
That is your good thing. You take the structures.
No, because they will hand over the old dilapidated structures. Now again, to remove it, my lord, I'll have to incur expenses.
I think you have got more than that.
My lord, from 75, my lord, from 75, they are using it, at least.
No,
from-
no, if those structures that they use it, they are still using it.
I'm
Those
told that
structures are
they
good.
They are not using those premises, my lord.
Huh?
I'm told that they are not using that premises. the
Very well.
structures.
If they do, then sell it, scrap.
My lord, that-
Scrap. But another new thing has been filed. This is a sir rejoinder. What is this? First time I have come. Rejoinder to my rejoinder. What are these? Who has filed this?
This I have filed a lordship.
What is it?
Bring record the money that I have invested so far, around 112 crores, 1 crore 12 lakhs. that I have invested
In respect to?
in respect to the work that has been carried out. Petitioner.
You can very well claim it by filing a suit against him.
Yes, sir. The lordship, I
The
think,
suit is pending.
they have filed a affidavit, bring on record.
Lordship, on the last occasion, the ONGC was directed to file one affidavit. Lordship has asked 3 specific queries. We have filed the affidavit, Lordship would find in page number 511.
490.
490, that has been.
Oh, there's some mistake in it. There are 5.
Para 4. Paso 11 pa. Lordship, the first query was. Lordship, no payment has been made in the partnership account, nor any reduction is made in respect of the PAN.
As you have not made any payment to them,
Lordship.
obviously the GST deduction would
No,
not be there.
no, Lordship. And a total of 78 lakhs, 5,200
Payable.
payable. And Lordship, I have also annexed the Disha file, that is the electronic file, that is record, contemporaneous record, that has already been submitted before your Lordship. I just annexed it to bring on record. To show that the initial, the process was initiated on 08/01/2024, Lordship, and it was got finally approved on 16/7/2024. That can be seen from the record. However, there is a mistake in the dates in the affidavit, Lordship. I may be allowed to correct it by hand. This record is annexed just to show that there was no any arbitrariness, Lordship. They have participated in the whole process and we have done it on their behest. And in the event Lordship finds that it should not have been done, if order on that count is filed, we have no problem. Anyway, we have to pay either of them, Lordship.
Now you make the payment.
Yes.
To them, taking into account that nothing has changed.
Lordship.
But as regards them, they will have a right to claim against him whatever
Lordship.
amount it is there, which is before the civil court, they can very well raise. It's a purely a dispute between you and him,
Lordship.
or which.
Yes, so just one document, your lordship, then I leave it to your lordship. 2 documents are there. Page 383 of my affidavit.
आगे कौन फाइल है, sir?
No,
Yes,
yes, paragraph 1 and 2, Your Lordship. This is,
Ah,
there was a dispute,
page 3.
383 of the affidavit in opposition filed by me.
That is 383 is some part of some document.
This is a settlement between me and the petitioner.
So it is being signed by Miss Ruhina
Gogoi and as Pratik Maskara. Pratik Maskara is me and Rohini Gogoi is the
No,
petitioner.
that
cannot be
document is not at
383.
383.
It cannot be 383.
It is straight.
No, it's 383.
Huh?
Not the sir rejoinder, the affidavit in opposition.
Understood. Your affidavit in opposition starts from 286.
Yes.
To 453.
Yes, 383.
383 is the copy of the minutes.
Yes, copy of the minus. This is a settlement agreement between me and the petitioner. Paragraph 1 and 2, Your Lordship.
You have changed the date. It is
Yes,
not 383.
383. The 3rd December.
383.
Ah.
Dates have been changed. It is annexure 8.
7, Your Lordship.
Part 7. No, I can't find out that. Annexure 8 is the suit.
And actually it is a NI case, but because in compliance of this affidavit, this
You are into annexure 7.
8 is the NI case.
This is page 392. Anyways, come.
This is the minutes that I'm talking about, Your Lordship. I'm relying on paragraph 1 and 2.
And then
And paragraph 2. One is the share of profit and paragraph 2. There's only one contract of ONGC. Now, if Your Lordship sees my suit, because in compliance of this, he has paid 6 amount of checks to me amounting to 1 crore 52 lakhs in terms of clause 1, which was bounced because of insufficient fund, and I had instituted the NI case. Now, if thereafter, it is in during this time that he has started disputing those documents and the change of vendor code. Then I was compelled to file the suit at page 398, where one of my prayer, if Your Lordship sees at 422.
wait.
420.
Don't come to that yet. Your suit is annexure what?
Next year, 9398.
Yes, what is that?
The suit, because 6 checks he has already paid, admitting that
Okay.
document. The
So
suit,
this is therefore,
Huh.
Mr. Sharma, your
Yes.
dispute is with him. There's no quarrel with that.
yes.
There's no
I'm
quarrel with that.
Seeking protection in terms of para 2.
How can I protect you?
The Lordship just,
No, we are concerned with the conduct of the ONGC qua the petitioner.
what
Do you have an agreement with the ONGC as of now?
I am trying to impress upon Your Lordship is this, Your Lordship. It is an admitted fact that he has taken money from me. The agreement settlement says that I am entitled to future payment from the ONGC, also share of profits, meaning thereby either I have invested or I participate in the work. Thereafter, it is during that time, he has disputed those documents. These documents were exited. He has now started to dispute the affidavit, the cancelled checks, the mandate form, everything. Because of the execution of the document, certain rights have been created in my favor. Now, after filing of the suit, where one of my prayer is that ONGC not to disburse the money to anyone till this is decided. He appears there, then comes and file this writ petition,
Did
disputing.
you get an injunction there?
No, the injunction has been heard. 21 injunction petition is being heard now. 21/7 was the last day where hearing could not take place because of the waterlogging. Now date should be after 15 August. So that injunction petition is pending, Your Lordship. Now, after appearing in the suit, he has come up filing this writ petition. He has disputed those documents way back in September. He didn't file it. After filing now, only my prayer is that it is a disputed matter of fact, his dispute. He is disputing those documents. He has not lodged an FIR till date. Whether by disputing those documents, is he entitled to any equitable relief from this honorable court? And whether there is any arbitrariness on the hands of ONGC when he has participated in the process of changing the vendor code all throughout. Now he wants to come back out of it because he has acted on the settlement. And to deprive that, whether the conduct would be taken into account by this honorable court. That is my humble submission. And if your lordship is inclined to give any order, what I'm seeking is that this prayer two of my suit and injunction, it is not affected by any observation by your lordship. That is my humble.
It won't be affected. I will only hold that unless and until there is a novation of a contract which ONGC enters into an agreement with the third party, the partnership firm, ONGC is bound by the agreement entered in petitioner and so on. That's my point. As regards your claim, which is the subject matter of the suit, the said suit shall be decided inter se between the parties, including the ONGC. Going to direct any payment to be made to the petitioner. That is the subject matter which has to be taken by them. But ONGC would be bound as per the agreement unless there is a novation with the final order. Yours is not affected. If you get an injunction out there, good. If you don't get an injunction, that's a different thing. And they will be paying the payment and you can very well claim it from him. That is his. Heard Mr. M. Goswami, the learned senior counsel, appearing on behalf of the petitioner. I only wanted to get it from them as to whether any payment has been made. Because now what has happened? Once the payments are made, there's a deduction against a particular amount. There's a GST deduction also made against a particular amount. All these things will come in. So now they have not done so. So under such a word, there is no problem with this. Heard Mr. M. Goswami, by so-and-so appearing on behalf of the petitioner. Mr. P. Purva appears on behalf of the respondent 1 and 2. R. Sharma appears on behalf of the respondent 3, 4, 5, and 6.
3, 4. 3 and 4.
3 and 4. I think the petition has been filed. Take your seat.
Good.
By the petition. Seeking a direction upon the respondent number 1 to restore the petitioner's account number 106371699153 maintained in the State Bank of India ONGC Colony branch semicolon PAN card number being AGA EG 1980B and GSTIN 18AGAPG 1980E17ZV linked to the vendor code 824091. In addition to that, the petitioner have also sought for appropriate directions upon the respondent number 1 not to unilaterally change the status of the petitioner under the contract agreement to that of a partnership firm. The brief facts which led to the filing of the present writ petition is that the petitioner is a registered government contractor with the respondent Oil and Natural Gas Corporation, bracketed ONGC, and claims to have executed several works. Full stop. The contracts were executed by the petitioner in his individual capacity. Petitioner have been provided a vendor code bearing number 824091. The bank account which is associated to the vendor code have always been 1063716915 and the corresponding PAN card number is AGAPG 1980B and the ZISTN is so and so. Agote number to pose. In respect to a tender, more particularly, the annual rate contract for laying in maintenance of oil oblique gas oblique water rejection oblique effluent pipelines in Assam asset for 3 years. The petitioner participated in the said bid tender process and was issued a notification of award dated 28/9/2022. A contract agreement was entered into by and between the respondent number 1 and the petitioner on 31/3/2023. The contract agreement has been enclosed as Annexure B to the writ petition. Wherein it is clearly mentioned that the ONGC had entered into an agreement with one MS Ruhini Gogoi, a proprietorship firm having its registered office at Modgaon, bracket Lokwa, MOUTGAOWON, bracket Lokwa, PO Modgaon, Tipsagar 785686, Assam. It is also relevant to take note of that clause 1.1 of the said contract agreement specifically mentions that a contract shall mean a written contract signed between ONGC and the contractor, including subsequent amendments to the contract in writing thereto. In other words, if there is a modification of the said contract, there has to be a document in writing. It is an admitted case on behalf of, as mentioned in the writ petition, that the petitioner had entered into a partnership with the respondent number 3 and respondent number 4 on 28/12/2023. The said partnership agreement entered into by and between the petitioner and the respondent number 3 and 4 have been enclosed as Annexure C to the writ petition. In terms with the said partnership agreement, the partnership would commence and are deemed to have commenced on from 17/4/2023. It is the categorical stipulation in the said partnership agreement that the petitioner herein, who is the party in the first part, would be converting the business of Rohini Gogoi from proprietorship to partnership, and the business in the co-partnership would be carried out in the name and style of Rohini Gogoi. It is the claim of the petitioner that without the petitioner's knowledge, the respondent number 3 and 4 took steps before the respondent number 1 and 2 for converting the agreement entered into by and between the petitioner's proprietorship firm with the ONGC to that of the partnership firm with the ONGC. And in that regard, the petitioner have also issued certain communications to the respondent, which have been enclosed as Annexure E, as well as Annexure F Collie to the writ petition. The grievance of the petitioner in the present proceeding that the respondent number 1 and 2, without carrying out any amendment to the written contract, entered into on 31/1/2023, much prior to the constitution of the partnership firm, have unilaterally changed the bank account, comma, the PAN card as well as the GISTIN from that of the proprietorship to that, from that of the proprietorship to partnership. And it is under such circumstances the present writ petition has been filed. The records reveal that upon filing of the present writ petition, the learned coordinate bench of this court by an order dated 7/1/2026 issued notice pursuant thereto. The respondent number 3 and 4 herein filed an application before this court which was registered and numbered as registered and numbered as IA number 2018/2026. IA number 1065/2026. Seeking leave of this court to be impleaded to the present proceedings. This court, by an order dated 14/5/2026, arrayed the respondent number 3 and allowed the application, being IA civil number 1065/2026, and the respondent number 3 and 4 were arrayed as parties to the present proceedings. The records further revealed show that the respondent number 1 and 2 had filed an affidavit in opposition on 17th of February 2026, wherein the maintainability of the present writ petition was questioned. It was further mentioned in the said affidavit in opposition that it was at the instance of the petitioner. The bank account, the PAN card, as well as the GISTN were changed from the proprietorship firm to partnership firm. However, keeping the vendor code the same. In that regard, the various documents which have been submitted by the petitioner before the respondent number 1 and 2 were enclosed to the writ petition, to the affidavit in opposition. An affidavit in reply thereagainst was filed by the petitioners. Stating inter alia that the core facts on the basis of which the edifice of the instant petition lies are not in dispute. It was mentioned that the ONGC changed the petitioner's vendor status and the bank oblique payment details without issuing any notice to the petitioner and without obtaining confirmation directly from him. It was alleged that the illegality lies in the ONGC acting upon a third party communication without carrying out the verification with the petitioner. This court also finds it relevant to take note of the affidavit in opposition filed by the respondent number 3 and 4. In the said affidavit in opposition, the respondent number 3 and 4 submits that the dispute in question is purely a civil dispute between the respondent number 3 and 4 with the petitioner, and the public law remedy have been sought to be invoked after knowing fully well that the suit was filed by the respondent number 3 and 4 against the petitioner. It was further mentioned that the petitioner owes an amount of rupees 1,57,20,639 to the respondent number 3 and 4. And in that regard, certain checks were issued which have bounced, for which proceedings under Section 138 of the Negotiable Instruments Act 1881 have been initiated against the petitioner. A suit being title suit number 30/2025 have also been filed by the respondent number 3 and 4 against the petitioner as well as the ONGC, wherein not only claims have been made as regards the amount which the respondent number 3 and 4 are entitled to, claims to be entitled to, but there is also an application, there is also a prayer for permanent injunction thereby restraining the ONGC from making any payment directly to the petitioner. In addition to that, there is also an injunction application filed, which have been registered and numbered as Ms. J case number 59/2025, which is presently pending. The petitioner has also filed an affidavit in reply, denying to the various statements and allegations made in the affidavit in opposition filed by the respondent number 3 and 4. In the said affidavit in opposition, affidavit in reply, the petitioners have categorically mentioned that the dispute between the petitioners as well as the respondent number 3 and 4 has nothing to do with the conduct of the respondent number 1 and 2 in changing in unilaterally changing this bank account, the PAN card, as well as the GISTIN. It is also mentioned in the said affidavit in reply that as regards the activities of the respondent number 3 and 4, the same have been duly reported by filing an FIR on 19/8/2025. This court heard this present petition in detail on 16/6/2026 and 23/6/2026. While hearing the petition, this court sought for certain clarifications from the respondent number 1 and 2. In the order dated 23/6/2026, clarifications the clarifications so sought for have been mentioned in paragraph number 3 and 4 of the order dated 23/6/2026, and the same is reproduced hereunder. On the basis of the order dated, in view of the order dated, in view of the order dated 23/6/2026, the respondent number 1 and 2 had filed an additional affidavit and provided and provided the clarifications stating inter alia that no payment have been processed or released in favor of the bank account of the partnership firm. It was further mentioned that upon verification of the accounts and the running bills maintained by the respondent corporation, an amount of rupees 78,05280 is payable in respect to the work presently carried out MS Ruhini Gogoi. It is further mentioned that there has been no deductions made with reference to the PAN and the GISTIN of the partnership firm. It was reiterated that it was at the request of the petitioner. The process was initiated on 1/8/2024. And the procedural formalities and interdepartmental scrutiny was duly carried out. And the final approval was accorded on 16/7/2025.
Lordship, there is a mistake in the dates, Lordship, I told you. That is 08/01/2024, initiated on 08/01/2024.
08/01.
2024, and approval was accorded on 16/7/2024.
24. The first date is okay. The second date is
No,
wrong.
first date is, Lordship, not, that is not 8/1, it is 1/8.
You have mentioned 1/8 only at page 513.
No, it would be 08/01, Lordship.
8/1.
8/1.
8/1.
8/1,
January instead of 1st August.
8 January
2024
2024, and 16th April,
16/7.
2024.
16/7/2024. And in that regard, have enclosed the DISHA file, DISHA file, as annexure 2 to the additional affidavit. This court also takes note of that the respondent number 3 and 4 have also filed a sur rejoinder to the affidavit in reply filed by the respondent number, by the petitioner. Wherein further details of the investments which have been made by the respondent number 3 and 4 in respect to the contract in question have been mentioned.
But we have not got an opportunity to respond to this. It's their assertion.
You want an opportunity?
No. We do not.
You want an opportunity? I can adjourn it today. No problem. Mr. Chaudhary, you are waiting for your matter. So we'll take it up at 4:45, your matter. Remaining.
No, Lordship, I'm just saying that they
Look
have
into it
asserted.
properly at 4:45.
I'm sorry, Lordship. I'm
No,
extremely
we
sorry.
take it up at
I'm
4:45.
sorry, I didn't mean to do that.
We take it up at 4:45. Let us take Mr. Chaudhary's matter. He's a blacklisted. You have no problem with that.
I'm
Yes,
extremely
Mr.
sorry if I
Chaudhary.
offended the court. It is just that they've asserted, that's all I.
You want an adjournment for that?
No, we do not. I'm certainly do not. I've come all the way, Lordship, only to face. Just-
I know what I'm writing out. It is he who is claiming it.
Extremely sorry. I didn't mean to.
We'll have it at 4:45, the remaining part of the judgment. Yes, Mr. Chaudhary, let us take blue dreamers out here. Yes, have you gone through Technogate? You don't have a case.
Some aspects are there, my lord. that-
Okay, tell me.
My lord may see page 44, my lord. This is where the dispute arises.
What is the dispute?
Dis- Dispute is that, my lord, it is relating to the warranty. Because contract tenure had ended and they had, my lord, supplied the equipments. But my lord, there was a grievance regarding quality of the equipments, and in the show cause also, my lord will say that it has been mentioned that they were asked to remedify those defects because it was under the warranty period, but they have not done so, my lord. So this was resorted to. Blacklisting was, my lord, resorted to. And my lord, in Blueprint's case, my lord, there the honorable court had specifically noted that there was disputes from both the sides, and an arbitration proceeding was also initiated. So that is why, my lord, it was considered as a genuine, my lord, civil dispute. Here it is a little different, my lord, the factual parts, because it is relating to warranty. After performance of the contract, my lord, a warranty is also there in the clause, in the tender clause.
If there's a breach in the warranty, can you blacklist it? My question is there.
Blacklisting, my lord, it is.
Because your contract now only says that if there is a termination, you can
Yes.
go for blacklisting. Which term is also goes against, very much goes against blue dreams. That term is contrary to the law laid down by the Supreme Court. So my question is now out here as to whether now in view of if there is a breach of the warranty, can you blacklist?
Because in the petition itself, my lord, they have relied on Patel Engineering's case, my lord. In Patel Engineering, the observation is that the power of blacklisting in any public authority, my lord, is inherent. Then need not
There's no
be a-
quarrel with that.
Yes,
You
sir.
have the power of doing it. My question is out here is let's see your order of blacklisting.
That is at 136, my lord.
Now, whether a regular operation and maintenance was a part of the contract.
It is not a part of the contract, my lord.
Heard Mr. I. Chaudhary, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the forest.
For my lord, one more submission, if I
Very bad. You should not have done this.
that my lord, this order is has blacklisted, my lord, the petitioner as well as the equipment manufacturer, my lord. let it be, my lord, only qua the petitioner, my lord, because it is concerning quality of the equipments and the manufacturer has not come before this court. So my
This
lord,
is only filed by Brihaspati Technologies
Yes,
Private Limited.
yes, ma'am.
So this petitioner only has agreed by this order. So you have blacklisted whom?
the petitioner as well as the equipment manufacturer. Page 138.
The
my lord.
original equipment manufacturer of revision in the negative list of Kaziranga Paper, period of 5 years. And 5 years, you cannot do like this, no? 5 years. There has to be some, as per that, there is a particular, you do it, so there is a particular year by the central government or the state government, what is that?
Central,
Which makes it clear that it can be for a period of 2 years. And beyond that, there has to be a further something more good reasons has to be assigned.
there is a central government guideline which says 2 years and at best, and that too, there are some preconditions under which they can, if I remember correctly,
Period more than that.
maximum 1 more year. But that they
No,
will obviously say that it is not applicable to them because it is the state government. State government does not have any such guideline.
Yes.
And the
I
other,
think the petition has been filed by the petitioner. Being agreed by the order, by the order dated 21/2/2023, by which the petitioner was put in the negative list of the Kaziranga National Park and Tiger Reserve, Assam, for a period of 5 years from the date of issue of the said letter. First. Brief facts of the case. On 21/5/2018, the Director, Kaziranga National Park and Field Director, Kaziranga Tiger Reserve, floated a tender for work for supply of automatic sensor-based vehicle speed regulatory system with requisite equipments at 6 specified animal corridor sections on NH 37 in National Park for management of vehicular traffic during wildlife crossing. The petitioner, being interested, submitted its bid, and the petitioner was evaluated as the L1 bidder for supply of the requisite equipments and ancillary services by the work order dated 9/1/2019. A contract agreement was also entered into by and between the petitioner and the respondent number 5 on 25/1/2019, and the contract value was rupees 1598,13,576 for installation of automatic sensor-based vehicle speed regulatory system with requisite equipment at 6 specified animal corridor sections on NH 37 in Kaziranga National Park for management of the vehicular traffic during wildlife crossing. Pursuant to the said pursuant to the contract agreement, it is the case of the petitioner that the petitioner started execution of the work on 23/3/2019. Materials and equipments were delivered at the project site, and as per the agreed payment terms envisaged in the contract, a bill dated 25/3/2019 for an amount of of the 50% of the contract value, that is rupees 799,06788, was raised by the petitioner company. Against the bill dated 25/3/2019, a partial payment of rupees 428,14,200 was received by the petitioner by the check bearing number 933,988 dated 30/3/2019. Further to that, on 23/2020, a further amount of rupees 692,66,730 was received by the petitioner company from the Treasury Office of Bukakhat. It is the further case of the petitioner that upon receipt of the amount of rupees 692,66,730, the petitioner retained an amount of rupees 370,92,586 and thereafter returned the excess amount of rupees 314,00,000 by depositing the same in the Kaziranga Tiger Conservation Foundation on 6/4/2020 upon a request made by the respondent number 5. On 2/11/2020, the petitioner sent a letter addressed to the respondent number 5 requesting for the release of an amount of rupees 314,00,000. In the said letter, the petitioner also confirmed, as requested by the respondent number 5, that the amount of rupees 314,00,000 was deposited by the petitioner in the Kaziranga Tiger Conservation Foundation on 6/4/2020. On 24/5/2022, a letter was issued by the respondent number 5 stating inter alia that an amount of rupees 314,00,000 was released by the check dated 9/11/2020 as per the request of the petitioner. However, it was stated that during the audit it came to light that the petitioner had erroneously deposited rupees 304,60,000 instead of rupees 314,00,000. And hence the petitioner was demanded to refund the excess amount of rupees 9,40,000 along with interest. In response to the said letter dated 24/5/2019, the petitioner sent an email on 6/6/2022 by attaching the RTGS customer acknowledgement copy from the Indus in Bank dated so and so for an amount of rupees 314,60,000. And it was further mentioned that due to the negligence of the bank, an amount of rupees 304,60,000 was deposited instead of rupees 314,60,000. It was also mentioned that as on account of the ongoing pandemic, COVID-19 pandemic, the petitioner could not notice the said aspect. The petitioner further stated in the said email that the excess amount of rupees 940,000 would be made and requested not to impose interest on the same. Be that as it may, the petitioner received another letter on 9/6/2022 directing the petitioner to deposit the excess amount, including interest at the rate of 18%, amounting to the tune of rupees 11,93,800 within 7 days. The petitioner, by an email dated 3/9/2022, informed that the amount of rupees 9,40,000 have already been paid on 23/6/2022 and 24/9/2022 in two installments of rupees 4,000, 4 lakhs and 5,40,000 respectively. The petitioner also mentioned that the additional penalty charge of rupees 253,800 was also deposited. Did you pay that? On 7/10/2022. The entire contract work, as stated by the petitioner, was completed on 21/12/2020, isn't it? With the delivery, installation of the requisite equipments to the satisfaction of the respondent authorities. However, the total payment was made. The complete payment was made by the respondent authorities on 28/3/2022. To the surprise of the petitioner, a show cause notice was issued by the respondent number 5 on 27/12/2022, asking the petitioner to explain within 15 days as to why the petitioner and the original equipment manufacturer should not be placed in the negative list of the Department of Environment and Forest, Government of Assam. Petitioner submitted a reply on 12/1/2023 dealing with each of the allegations. Thereupon, the impugned order was passed. On 21/2/2023, and the petitioner being aggrieved, thereupon had approached this court by filing the present writ petition. The record reveals that this court, by an order dated 26/2/2024, issued notice Two years thereafter. The respondent number 5 filed an affidavit in opposition justifying the impugned order dated 21/2/2023. The petitioner have also filed an affidavit in reply on 27/7/2026, reiterating to the statements made in the writ petition and denying to the statements and allegations made in the affidavit in opposition. When the matter was listed before this court on 27/7/2026, this court heard the matter partially and taking into account that the writ petition, that there is no interim orders passed.
There is an interim order. man. There is an interim order.
When?
While issuing notice, my Lord Justice Goswami's order, there is an order on 12/6/24.
Oh, okay.
It was after issuance of notice. On 12/6/2024, there is a interim.
Interim order was passed subsequently.
Subsequently. Yeah.
Account, and this court heard the matter on taking into account this court affidavit in reply filed on so and so. Taking into account the issue of blacklisting, this court have directed the matter to be listed today for final disposal. I've heard Mr. I. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, who submitted that the contract in question was completed to the satisfaction of the authorities in the year 2020. Payments were made
The final
after
payment was
2 years on 23,
28/3/22.
28/3.
28/3/22. Final payment was made.
Huh?
Final payment was made.
And the complete payments were made on 28/3/2022. Thereupon, most arbitrarily, proceedings were initiated for putting the petitioner as well as the original manufacturer in the negative list. That too, on allegations which on the face of it do not exist. The learned senior counsel submits that though the authority has the jurisdiction to initiate steps, to pass orders for, to take steps for blacklisting in view of the settled principles of law. But such actions for blacklisting has to be exercised in a fair and a rational manner. And it cannot be arbitrary. The senior counsel further submitted that in addition to that, the state can initiate the process of blacklisting for a legitimate purpose and not of a of a proceedings of a present type. Full stop. The learned counsel further submitted that it is now well settled by the Supreme Court in the case of Blue Dreamers versus
Kolkata Municipal.
Kolkata Municipal Corporation,
Kolkata Municipal Corporation, reported in
2024 15 SCC 264.
wherein the Supreme Court made it clear as to under what circumstances the extreme step of blacklisting can be taken, more particularly when blacklisting amounts to a civil debt. The learned senior counsel also referred to a recent judgment of the Supreme Court in the case of Technocrit versus
Chhattisgarh Textbook Corporation and
reported in
2025 SCC Online SC 343.
wherein the Supreme Court went to the extent of observing that when the law is well settled as to when proceedings for blacklisting should be initiated, issuance of a show cause notice when there arises no question of initiating a blacklisting proceedings amounts to an empty formality. On contra, Mr. I. Botaku, the learned counsel appearing on behalf of the Forest Department, submitted that the issue involved in the present petition is not is factually different from the facts which were involved in the case of Blue Dreamers. Blue Dreamers Advertising Private Limited Supra, as well as Technoprint Supra. He submitted that in the instant case, the respondents who have supplied and installed the machineries did not take care to follow it up by providing the necessary
Rectification of defects.
rectification of defects. But that is not what you are saying. Your order also does not say that. Necessary, put the better word.
Necessary
There was no rectification, was not the question.
in pair of
Follow-up action. I think better, na?
pair of
No, your order does a follow-up action.
remedy defects. We have used the
No,
word
kindly see here.
affidavit.
No, forget about affidavit. What affidavit? Kindly see your order. Yeah. Kindly see number 5, 137. Follow-up action.
Follow-up action.
Follow-up
Follow-up
action,
action.
better. Necessary follow-up action which was required. Though the respondents have extended full cooperation, rendered all facilities and advances to the petitioner liberally. Full stop. The learned counsels for the Forest Department further submitted that although the petitioner have informed the respondent authorities that an amount of rupees 3,14,600, 3 crores 14 lakhs 60,000 was deposited, but in fact, an amount of rupees 3 crores 4,000, 3 crores, 4,60,000 was deposited. In addition to that, the learned counsel further submitted that a performance bank guarantee of rupees 159,81,357 ought to have been extended during the period of the work, but that the same was not done. He therefore submitted that actions taken on behalf of the respondents of putting the petitioner as well as the original manufacturer in the negative list on by the impugn order dated 21/2/2023 is not required to be interfered with. This court have given an anxious consideration to the respective submissions and have also perused the materials on record. Including the impugned order, which was passed by the respondent number 5. The materials on record clearly show that though the petitioner initially claimed that the amount of rupees 3 crores 14,60,000 was refunded to the petitioner, respondent. But in actuality, on 6/4/2020, the amount of rupees 3 crores 4,60,000 was deposited. And subsequently, the respondent authorities had issued a communication that the petitioner, on coming to learn the said aspect, upon being informed had submitted an apology and submit with a prayer that the additional penalty by way of interest at the rate of 18% should not be imposed upon the petitioner. The respondent authorities, however, did not agree to the same. Resultantly, the petitioner not only paid the amount of rupees 9,40,000, but also the additional penalty of rupees 2,53,800, and this aspect was duly informed to the respondents on 1/7/2022.
7/10/22.
On 7/10/2022. Under such circumstances, in the opinion of this court, when the respondents have duly accepted the amount of rupees 9,40,000 along with the additional penalty, the question of initiating a proceedings for blacklisting, in the opinion of this court, cannot be said to be reasonable action on the part of the respondent authorities. This court further takes note of that in the impugned order, it is mentioned that the respondent authorities have not provided the follow-up action, which forms one of the reasons as to why the blacklisting proceedings was initiated. It is seen from the materials on record that the work in question was completed and handed over on, give a date, na?
21,
21?
21/12/2020.
21/12/2020. And the complete payment was made only on 28/3/2022. There is no mention, either in the show cause notice or even in the impugned order, that there were certain defects pursuant to the completion of the work. And these work were then and thereupon, there was no follow-up action. Under such circumstances, the initiation of the show cause proceedings on the basis of the said reason cannot also be said to be reasonable and rational. On the question of not providing an extension to the performance bank guarantee and an action being taken for show cause after the successful completion of the work, in the opinion of this court, cannot also be said to be reasonable, rational, and rational. In the backdrop of this court above, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Blue Dreamers Advertising Private Limited, wherein the Supreme Court categorically observed that blacklisting is a drastic remedy and orders passed has to be subjected to rigorous scrutiny. At paragraph number 34, the Supreme Court observed that merely saying that a blacklisting order carried reasons is not good enough. There has to be a justification. There has to be reasons justifying the invocation of the penalty of blacklisting. And is blacklisting proportionate to the infractions committed by the contractor? At paragraph number 24 and 25 of the said judgment, the Supreme Court observed as to under what circumstances a blacklisting can be permitted. The said paragraph 24, 25, and 26. The said paragraphs, paragraph 24, 25, and 26 being relevant are reproduced hereunder. This court further takes note of the judgment in the case of Technoprints, wherein the Supreme Court, relying upon the judgment in the case of Blue Dreamers Advertising Private Limited, Supra, observed that when the guiding principles have been explained by the Supreme Court in various judgments as to when and in what circumstances the blacklisting order can be passed, the authority concerned has to keep in mind such principles before initiating a show cause notice. It was categorically observed that if these principles are not borne in mind at the time of initiation of the show cause notice, the said show cause notice would be an empty formality, and as such, the said show cause proceedings cannot be continued. Paragraph number 27, 28, and 29 and 30 being relevant are reproduced hereunder. First, in the instant case, it would be seen, clearly seen, that the respondent authorities have initiated the show cause proceedings much after duly accepting the additional penalty in respect to issues which were not a part of the contractual obligations, as well as in respect to a contract which had been successfully completed. In the opinion of this court, the said blacklisting order cannot be said to be a reasonable, rational, as well as legitimate exercise carried out by the respondent authorities. Accordingly, the writ petition stands disposed of with the following observations and directions. The impugned order dated so and so, dated 21/2/2023, issued by the respondent number 5, is set aside and quashed. Number 2. During the course of the arguments, the learned counsel, standing counsel appearing on behalf of the petitioner, a respondent has submitted, learned counsel appearing on behalf of the respondents have submitted that as the petitioners have approached this court, the blacklisting order dated 21/2/2023 should not be set aside qua the original manufacturer. The said submission, in the opinion of this court, is completely misconceived. More particularly, when the original manufacturer was never put to notice, and the allegations so made in the show cause notice as well as in the impugned order do not relate to the original manufacturer.
When a copy has not been marked, Madam.
No, it's okay. No, show cause notice have not been issued. Nothing. Under such circumstances, it is therefore the opinion that the impugned order dated 21/2/2023 cannot withstand the scrutiny of law for which the same sense sets aside qua the original manufacturer also.
Right.
Unnecessarily, you have done some cost. 5 lakhs. Let me come back.
Okay.
May I please, your lordship?
Yes, did you have the records?
Yes, ma'am. It's in vernacular, my lord, but after going through these records, my lord, although I'm not very well in Silatia Bengali language, my lord, I can understand, my lord, that first meeting was first scheduled, my lord, on 27/6/2025. On that day, my lord, private respondents, they are numbered in 6, my lord. They were present and petitioners were absent. That is why the meeting was postponed, my lord. And thereafter, on 2/7/2025, it was rescheduled. On that day also, my lord, that was postponed because the petitioners were absent, my lord. And thereafter, my lord, on 7/7/2025, the meeting was fixed, my lord, again. And only 6 members of private respondents, they were present initially, my lord. And due to, my lord, non-availability of one, my lord, one person, my lord, that was initially cancelled, my lord. But thereafter, after 1 hour, he came, my lord. Thereafter, meeting was held, my lord. That is the record.
Can it be after 1 hour?
That is record is saying, my lord.
No, we do one thing.
My lord.
We interfere with this meeting.
Right.
Petitioners are here.
Yes. Respondent.
We have put to them to notice.
Yes, my lord.
We fix a meeting. This
For the
court
particular-
fixes a meeting
Yes, my lord. That will be.
and
yes,
directs the parties to be present on that
my
day.
lord, my lord. Very well.
On which date the meeting will be done?
My lord, my lord.
And we take it as the submission of the DC.
Yes, ma'am. My lord. Everyone is here, my lord. My lord.
I don't know.
Yes.
Next time you cannot say that I am not present. You are put to notice and it is your specific submission. How many members are there in the Gaon Panchayat?
10, my lord.
10, ma'am.
And they are the 4.
4.
And they don't appear.
Yes.
And for that the meeting could not be held.
Yes. Yes, ma'am.
And he has given an undertaking that the meeting would be held. He will participate in the next meeting.
And there are some other prayers that cannot be, my lord, because there also one disqualification under 111.
Who?
There, my lord. Prayer is also there, my lord. That cannot be. Lordship's order is there, my lord.
111 for what?
For disqualification of some.
My lordship, that this I'm not pressing, my lordship.
Not. Heard Mr. S.B. Loskor, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1,
I'm for 1 and 2, my lord. So 1, 2, 4, 5, and 6.
5 and 6.
Only 3 and 4.
Mr. H. Sharma appears for respondent number 3 and 4. And Mr. So-and-so appears for respondent number 7 to 13.
Yes.
7 to 13. The present petition has been filed challenging the order dated, challenging the meeting of the newly elected members of 5 number Buribail Gaon Panchayat under Borkhola Anchalik Panchayat, which was held on 7/7/2025. Solely on the ground that the said meeting was held in contravention of rule, Mr. Loskor,
Rule 46, my lordship. Rule 46.
Rule 46.
Of the Assam Panchayat Constitution Rules 1995.
Of the Assam Panchayat Constitution Rules 1995. First, taking into account the limits, taking into account the grievance of the petitioner and the sole case of the petitioner lies on the compliance of Rule 46 of the Assam Panchayat Constitution Rules 1995. For short, the rules of 1995. And more particularly, sub-rule 3 of Rule 46. The same is reproduced here in under. From a perusal of the above quoted sub-rule of Rule 46, Rule 1, 2, and 3 of Rule 46 is reproduced here in under. From a perusal of the above quoted rule, it would be seen to show that the Deputy Commissioner or the subdivisional officer, as the case may be, shall call the first meeting of the Gaon Panchayat under clause B of subsection 1 of section 6 of the Assam Panchayat Act 1994 by fixing a date and causing a written notice specifying the date, time, place of the meeting to be served on each elected member of the Gaon Panchayat concerned at least 7 days before the date so fixed. Such meeting is also required to be presided officer by an officer authorized by the Deputy Commissioner or the subdivisional officer as the case may be, and such officer shall not be entitled to vote. In terms of sub-rule 3 of Rule 46, if 1/3 or more of the total number of members called to the meeting under sub-rule 1 are not present within an hour of the time fixed for the meeting, the Deputy Commissioner or the subdivisional officer, as the case may be, or the officer empowered in this behalf, shall adjourn the meeting pending fixation of another date by the Deputy Commissioner or the subdivisional officer, as the case may be, not later than 15 days of such meeting. In the backdrop of the above, if this court peruses the minutes of the meeting, more particularly the translated version which has been certified by the learned counsel appearing on behalf of the petitioner, it would show that a meeting was convened at 1 p.m. on 7/7/2025. On account of the absence of the presiding officer, the meeting was cancelled. Thereupon, upon the direction of the Chief Executive Officer of the Jilla Parishad, one Srimati Pratima Dev was instructed to reconvene the meeting on the same date at 2 p.m. On the same date, at the same time at 2 p.m., 6 out of the 10 members were present. However, the remaining 4 members who are the petitioners herein did not attend on account of the want of notice that the meeting would be reconvened at 2 p.m. on 7/7/2025. The meeting proceeded with 6 members and certain resolutions were adopted. From a perusal of the Mr. S.B. Losco, the learned counsel appearing on behalf of the petitioner, submitted that the petitioners were not aware about reconvening the meeting on 7/7/2025 itself. Inasmuch as the said meeting can only be reconvened by the district commissioner or the subdivisional officer as the case may be, by fixing another date which is not later than 15 days from the date on which the meeting was fixed. He therefore submitted that the meeting which was held on 7/7/2025 at 2 p.m. is contrary to sub-rule 3 of Rule 46 of the Rules of 1995. This court, upon perusal of the materials on record, is also of the opinion that the meeting so-called reconvened at 2 p.m. on 7/7/2025, that too, at the direction of the Chief Executive Officer of the Jila Parishad, was not in consonance with sub-rule 3 of Rule 46 of the Rules of 1995. Accordingly, the said meeting dated 7/7/2025, being contrary to Rule 46(3) of the Rules of 1995, cannot be allowed to be sustained. This court also finds it very pertinent to take note of the submission of Mr. S. Dutta, the learned standing counsel of the PNRD, as well as the learned counsel, as well as Mr. S. P. Chaudhary, the learned counsel who represents the private respondents, who submits that it is on account of the petitioners. The meetings could not be held on 27/6/2025 as well as on 2/7/2025. And as such, specific directions should be issued so that on the next date, the petitioner cannot complain that they had no notice about the said meeting. Mr. H. Sharma, the learned counsel appearing on behalf of the district commissioner. Which one? District commissioner where? Tribhumi. You don't know for whom you are
Kasar
appearing.
district.
District commissioner Tribhumi submits.
Kasar man.
Kachar submits that this court may fix a date so that the petitioner at a later stage cannot again raise the issue that they had no notice. This court also takes note of that the elections were held as far back as in the year 2025. Until date, the first meeting of the Gaon Panchayat in question have not been held on account of the inadequacy of the quorum. And as such, there is a requirement of passing certain directions in that regard. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The impugn meeting, which was held on 7/7/2025, being in violation to Rule 46(3) of the Rules of 1995 is set aside and quashed. Taking into account that all the members of the Gaon Panchayat are represented before this court, and on behalf of the district commissioner, Kachar, a submission has been made to the effect that a date and time may be fixed for the meeting. This court fixes the meeting, the first meeting of the Buribal Gaon Panchayat on 11th of August 2025 at 11 a.m. Where it is to be held?
Well, same, my lord, the Gaon Panchayat, my lord, the Anchalik office of the Anchalik Panchayat, my lord.
In
Borkhola
office
Anchalik.
of the Borkhola Anchalik Panchayat. The petitioners are given due notice about this meeting, and as such, the said in view of the such directions, the petitioner is therefore put to petitioners as well as the private respondents are put to notice about the date and time and the place where the meeting would be held. This court further directs the respondent with the district commissioner respondent number.
District 3, my lord.
Respondent number 3 to pass appropriate to nominate an officer authorized to be present in the said meeting to administer the oath of affirmation to the members of the Gaon Panchayat, of the Buribal Gaon Panchayat, and conduct the meeting conduct the business of the meeting. There shall be no order as to
Private respondents oath, my lord, that's already they have taken oath, my lord.
oath again.
Yes.
So to conduct the business of the meeting. You inform this about this order. Otherwise, they will not know. What is this?
Lord, this is also, my lord, at the first meeting was not, my lord.
Oh, in addition to that one, Mr. Loskar, where is he? All other reliefs so sought for in the present with petition stands rejected. 111 is there, na?
My lord.
Yes.
My lord, this is also, my lord, in a similar footing, my lord. We are the, my lord, the members of the Haradatta Gaon Panchayat in the district of Kamrup. So, my lord, the first meeting, which was at least to be held on 9/6, my lord, 2025, my lord, is not in accordance with law, my lord, and therefore we are challenging the impugned speaking order as well as the, my lord, meeting which was held, at least to be held, my lord.
Where is the speaking order?
My lord may be pleased to find the speaking order starts at page 54, my lord. Uh-huh. Uh-huh. By speaking order, that is, no. এটাই স্পিকিং অর্ডার বুজি পাব তেনেকৈ গাতে এইটো মেইন নহয় জানো স্পিকিং অৰ্ডাৰ
So here there is a challenge to the appointment of election of the president and the vice president,
My lord.
or only the vice president.
No, my lord, both, my lord, president and vice president, because my lord, meeting was not at all, my lord, held. If my lord may be pleased to peruse the affidavit also, my lord, which the, my lord, co-district commissioner has filed, my lord. In paragraph 4, they have admitted, my lord, that what has actually happened on that day. Even the, my lord, proceeding books or the records has been, my lord, snatched and teared, my lord.
It is also reflected in the order itself.
My lord. So, my lord, this,
But in the order, it is categorically mentioned that as so far as the president is concerned, there is no dispute.
no, my lord, because the meeting was not at all, my lord, was quorum or the, my lord, the swearing in ceremony, nothing could be, my lord, done on that day, my lord.
Swearing in happened on 9/7.
Lordship, because of this unruly situation, that is why your lordship has directed me to place the minutes, lordship, I am placing it. Because of this unruly situation, it was cut.
Now the question is, here, the meeting was held. You
Meeting
have
was
a-
held, meeting was held, all the members were present, thereafter lordship, because of this unruly behavior of the 5 petitioners, the present petitioners, that much lordship, that 2 pages.
Like this?
Because, my lord.
They are persons lordship.
No, no,
they
no,
did it.
we have not done anything, my lord. It is the man and muscles, my lord. The meeting was totally interfered with, my lord, outside persons, my lord.
in
If
our-
they have entered into the room, my lord, and interfered with the meeting, my lord. That is the instruction, my lord, and those things has not been taken into consideration by the, my lord, the deputy commissioner, my lord.
The
Why?
circle officer was there.
No, circle officer was there, my
in
lord.
our,
The stand of the
may I
circle
please,
officer.
My
lordship,
lord.
in our affidavit, in paragraph 4, we have stated categorically, may I read lordship? Paragraph 4. Affidavit filed by the respondent number 3. Last paragraph, lordship. However, a group of 6 members comprising so and so daily represent petitioners began arguing among themselves regarding the post of vice president. This argument gradually escalated into a law and order situation. Although the authorized officer managed to bring the situation under control and meeting was declared closed by the chair, the unruly and disruptive member subsequently snatched the proceedings register and stuck out several pages. Lordship, this is not controverted by them, lordship.
No, no,
This
my
is
lord.
not controverted by them. This was not done by them.
No, no, my lord, we have not done, my lord. These are all, my lord, our representations, my lord, which we have, my lord, filed before the authority. They have not disputed our representations, my lord, in the affidavit. Only this paragraph, my lord. We have made several representations that these things are happened. So the meeting may kindly be convened in accordance with law afresh, my lord. Those representations, they have also acknowledged, my lord, before this speaking order was passed.
Did we interfere?
My lord.
It's a finding of fact under section 11.
No, no, my lord, my lord, not at all the meeting was convened, my lord. It was.
The meeting was convened. There is no.
No, my lord.
That the meeting
My lord,
was not convened.
meeting was, my lord, people were gathered there for the purpose of meeting.
So
But-
that means the meeting was convened.
No, meeting was convened, but for the very purpose, my lord, the meeting was convened. That purpose was not served in accordance with law, my lord. That is our case. Now, my lord, we have made repeated representations before the authorities, my lord.
But the findings of facts are there.
No, my lord, may kindly
This is
see, my lord. My lord, may kindly see the paragraph 4.
Because this is the authority done under section 11.
No, my lord,
Because
my lord, section 11 authority is the appellate authority, if, my lord, my lord, deputy commissioner under section 11, my lord. Now, the deputy commissioner has not taken into, my lord, contention of the, my lord, present petitioner which they have raised before the deputy commissioner, my lord.
question of facts.
No, question of facts is there, my lord, but the question of facts is proved by the records, my lord. My lord may kindly peruse that they have admitted that the papers,
Before a civil,
my lord.
civil court bar, lordship. They are bar under the civil court.
My lord,
Because this question I cannot decide. You see, the authority who can decide is the deputy commissioner. Unless you show that there is something which the deputy commissioner have not taken into consideration. Deputy commissioner has considered everything.
No, no, my lord, the deputy commissioner's contention and the affidavit
The
which is
fact
filed,
that
my lord.
there was a meeting convened in terms with section 46, there's no quarrel with that proposition. You were present. The fact, your allegation is, look here, the meeting which was convened for election of the president could not proceed in view of the hooliganism of the private respondent.
My lord, my
That's
lord.
your case.
That is my case and that has been,
Whereas
that
they
is,
deny, they say that it is
My lord.
absolutely your fault.
no, 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 my lord,
How can-
my, lord,
No, no,
my lord.
their case.
There stand, my lord, there stand, my lord, my lord.
Then I decide whose hooliganism.
No, my lord, from their very affidavit, my lord, may kindly see, my lord, what they have written. However, a
No,
group of,
it is not only that, it is there, forget about the affidavit, it is there, paragraph
no, no,
number.
paragraph 5 is
Kindly
there.
see page 54 of the.
Yes, yes, my lord,
order
page number
conference district.
84 I am reading, my lord. 84 and 85,
No, page 54,
my lord, huh?
page 54. These are things which are already mentioned out there.
No, no, my lord, page number 54, they have says that that during the said meeting, the president and vice president were reportedly elected as per provision of the so and so. My lord, there was no, my lord, even there is no scope of election or the voting or the, my lord, the quorum under section 46(3) was required to be done. Because, my lord, totally hooliganism was there, my lord. It has been, the meeting was entirely hijacked, my
You
lord.
filed FIR?
My lord.
Did you file FIR?
No, my lord, because the papers, it was within the, my lord, jurisdiction of the deputy commissioner and the government officials, my lord, who were present there. Now, my lord, they are required to take care of
No,
the, my
why
lord.
will the deputy commissioner
My
have
lord.
anything to do? He is the appellate authority.
No, my lord, we have,
They have looked into it, seen all the papers, taken the report of the authorized officer, the circle officer and all, and then they have submitted the report. Very difficult.
no, no, my lord, the situation, what has happened there, and my lord, I can understand, my lord, that such, sometime, my lord, the exact scenario, my lord,
No,
is very, My-
Mr. Bia,
My
tell
lord.
me under what circumstances I can interfere.
my lord, if the, my lord, rule 46, my lord, is not been complied with in accordance with the law, if the meeting was, my lord, from their affidavit, my lord, it was not a peaceful meeting, my lord.
So what? If there is not a peaceful meeting, should I be interfering?
Because, my
with
lord,
it?
the
So
very
what?
purpose of the meeting has not been done in
No,
accordance
that
with
cannot-
law, my lord.
so-
Rule 46, sub-rule 8, my lord.
Let me see. The district court shall, after
My lord.
completion of counting and
Meeting.
recording of votes received by each candidate for each of the offices, declare the candidates who have secured highest office numbers of votes,
My lord.
respective offices to be duly elected as president and so and so.
Now, who has got the highest
Case
vote,
of
my lord?
Quality of votes of two or where the declaration shall be made by giving the officers in the prescribed manner.
So, my lord, the
Now,
voting,
now tell me one thing.
my lord.
There must have been records of
Voting, my lord.
records of the votes being submitted.
My lord. It should be in
Obviously,
the
there
minutes.
has to be records because if we look into Rule 8,
Lordship.
sub-rule
Sub-rule
8, the deputy commissioner shall, the district commissioner shall, after completion of the counting and recording of votes received by each candidate for each of the offices, declare the candidate which have secured highest number of votes against respective offices to be duly elected as president and vice president.
Regarding that vote, Lordship, in the minus, there is no reflection possible, but even then, Lordship,
No vote.
My question is, did you take by vote of hands or what?
Lordship, I have to take as because your Lordship has directed me to bring that minutes.
Understood, I brought the minutes. but
Yes.
My question is,
Lordship, I have to take
question is,
instructions.
if you have declared, because if you see the impugned order, and whereas upon careful, herein says, whereas so and five other members filed petition before the High Court dismissed it, so and so, whatever may be. And whereas upon careful examination of all available records,
Lordship,
this cannot be the record only.
Lordship,
The report submitted by the circle officer,
Lordship,
Rongian Revenue Circle, and the authorized officer, and after due consideration of facts and circumstances of the case,
Lordship,
is of the considered so and so. So these must be recorded statements.
Lordship.
Where are those? Secondly, whether the voting was by how? How was the voting? Whether the voting was by show of hands or
ballot,
was
my lord.
done unanimously? Because here you are declaring somebody as elected.
Lordship. I have to, Lordship, I have to take that instruction.
Because on the last occasion, I only inquired as to whether there was any meeting held on 9/7. Meeting was held. There's no quarrel with that proposal.
Regarding these findings, Lordship, I have to bring the records. Lordship.
What is the based upon these findings are based upon? Now you produce the records on the basis of which the DC passed this order.
Lordship. Good evening.
That there has been compliance to 46. Because that is not mentioned in your affidavit.
Lordship, that is not mentioned.
This court have heard Mr. A.R. Bhuya, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioners, and Mr. H. Sharma, the learned government advocate, who appears on behalf of the district commissioner, Kamrup, and Mr. S. Dutta, who appears on behalf of the PNRD department. The order dated 5/11/2025 passed by the district commissioner, Kamrup, has been put to challenge on the ground that though the meeting was convened in accordance with Section 46 of the Assam Panchayat Constitution Rules 1995, but the meeting could not be progressed in view of the alleged hooliganism of the private respondents. And as such, there was no election to the post of president as well as vice president. Mr. A.R. Bhuya, the learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioners, submitted that a perusal of the order dated 5/11/2025, which is impugned in the instant proceedings, show that the deputy commissioner had exercised the powers which is akin to section rule 46(8) of the rules of 1995. But there is no basis on which the exercise to rule 46(8) could have been carried out without there being any voting. Taking into account the said allegations, and there is no reply, nothing mentioned in the affidavit filed by the respondent co-district commissioner. It is the opinion of this court that the records on the basis of which the impugned order dated so-and-so 11/2025 was passed by the district commissioner, Kamrup, be placed before this court. Mr. H. Sharma, the learned government advocate, during the course of in pursuance to the directions passed earlier, had produced the
Minute.
had produced this document known as
Minutes of the meeting.
I produced minutes of the meeting held on, what is the date? 9/7/2025. The said document be also, the said register be again produced on the next day. List this matter again on when, 7th of September?
Lordship.
Can it be in the month of August, my lord?
Why?
Because they illegally elected presidents, my lord, and
Who are you?
Lord,
You
we
want
are
to
the
be
members.
president?
No, my lord, we are the members elected, my lord. 6 members, my lord.
Okay, you are the members elected.
My lord.
But the challenge to the president is made on the 11th.
No, my lord, the section 11, my lord, is
How do you challenge the president? It will be under 111.
my lord.
Yes, 111.
Gaon Panchayat can be challenged.
11 is the power of district commissioner. Section 10.
My
Huh?
Section 10 is the election for president and vice president.
Right.
And section 11 is the district commissioner's power to interpret.
Yeah, so this is an order, and any dispute
Section
related
11.
by so and so shall be decided by the deputy commissioner.
Because 111 is disqualification.
my
But disqualification as regards 111 will apply for the president and the vice president's election.
For all the ward members.
No. In respect to disputes which are, or deficiencies or disqualifications which existed prior to that, they have no impact on the elections. But on the election of the president and the vice president, that can be looked into. Because there is nothing mentioned in the Constitution Rules 1995, which is akin to the representation of people's side. Anyways, good.
Well,
We have it when?
as per my lordship's convenience, my lord, if
Yeah, I am always there.
on 14th of August, my lord.
Here till 5:30. See the
On 19th of August, my lord.
face of Mr. H. Sharma waiting till 5:30 yesterday. Yes.
My lord. On 19th of August, my lord.
You can bring it by 19.
Sorry, boy.
15, yes, Lordship. After 15th of August, Lordship, it will be, Lordship, I will,
Let's have it on 27th of August.
Lordship.
Obliged.
Yes, where is Mr. Manish Goswami? We got mean to do. Station did not. Yeah. Very good. This court further takes note of that the respondent number 3 and 4 have filed a SAR rejoinder to the affidavit in reply filed by the petitioners. In the SAR rejoinder, respondent number 3 and 4 have placed further details of the investment in respect to the contract in question. In the backdrop of the above pleadings, this court takes up the submissions made by the learned counsels appearing on behalf of the parties. Mr. M. Goswami, the learned senior counsel appearing on behalf of the petitioners, submits that the issue involved in the present proceeding is as to whether the respondent numbers 1 and 2 can deviate from the written contract wherein the petitioner, wherein one of the contracting parties is a proprietorship firm of the petitioner. The learned senior counsel submitted that unless there is a novation of the contract dated so and so entered into by and between the petitioner and the respondent number 1 and 2, the respondent number 1 and 2 cannot recognize the partnership firm as an entity to the contract, in as much as the partnership firm has no privity of contract between the petitioner and the respondent number 1 and 2. The learned senior counsel further submitted that the dispute between the petitioner and the respondent number 3 and 4 has nothing to do with the contract between the petitioner and the respondent number 1 and 2. And as such submitted that the claims so made by the respondent number 3 and 4 in their affidavits, who are the petitioners, or even in the SAR rejoinder, has nothing to do with the dispute in the present proceedings. The learned senior counsel further mentioned that while the contract between the petitioner and the respondent number 1 and 2 still coexist, still remains subsisting, the vendor code, which is specifically assigned to the petitioner, is being used. The respondent number 1 and 2 on their unilaterally cannot change the bank account details, the PAN card, as well as the GISTN. Mr. P. Bulwer, the learned counsel, appearing on behalf of the respondent numbers 1 and 2, submitted that steps were taken by the respondent number 1 and 2 at the volition of the petitioner, inasmuch as the petitioner had approached the respondent number 1 and 2 on 8/1/2024. And it was only on after carrying out various checks and approvals and various checks and after carrying out various scrutinies on 16/7/2024, the petitioner's request was approved. The learned counsel, appearing on behalf of the respondent number 1 and 2, therefore submitted, relying upon the various documents enclosed to the affidavit in opposition, as well as the additional affidavit so filed, that these documents will clearly show that the petitioner had approached the respondent number 1 and 2. And therefore, the petitioner cannot complain by invoking the public law remedy before the court. Mr. Ashama, the learned counsel, appearing on behalf of the respondent number 3 and 4, submitted that the petitioner duly admits to the partnership agreement, as would be seen from the affidavit petition itself. And in the said partnership agreement, there is a clear stipulation that MS Rohini Gogoi, which is the proprietorship firm, the stipulation that the business of MS Rohini Gogoi, which is a proprietorship firm, would be converted into MS Rohini Gogoi as a partnership firm. The learned counsel, appearing on behalf of the respondent number 3 and 4, further submitted that huge amounts have been invested on the basis of the said partnership agreement. And at the time when the question of making payment arose, the petitioner have raised certain objections for which the payments which have to be made by the respondent ONGC have been not cleared. It is under such circumstances, so the learned counsel further submitted that the petitioners have issued certain checks to the tune of rupees 1,57 crore, so and so. And as these checks were bounced, were dishonored, the respondent number 3 and 4 have filed an application under Section 138 of the Negotiable Instruments Act 1881. In addition to that, a suit has been filed which have been registered and numbered as so and so, wherein various claims have been made against the petitioner and wherein the ONGC is also a party. The learned counsel further submitted that the dispute in the present issue, the dispute in question is a dispute which is pending adjudication before the civil court. And therefore, this court ought not to exercise its extraordinary jurisdiction. Further to that, the learned counsel submitted Mr. Ashoma, the learned counsel for the respondent number 3 and 4 further submitted that in the circumstance this court is of the opinion that there is a requirement of an interference, this court may kindly take note of the pendency of the civil proceedings before the court of civil judge Ipsagar, as well as the injunction proceedings, analysis and determination. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. Though various disputes have been raised as to whether the petitioner on his own volition applied before the respondent number 1 and 2 for changing the contract details for changing the bank details, PAN card and GISTN from proprietorship firm to the partnership firm. But fundamentally, it is but a perusal of the contract in question, which is annexure B, a perusal of the notification of the award dated 28/9/2022, as well as the contract entered into by and between the petitioner and the respondent number 1 and 2, would show that the contract still subsists between the petitioner as a partnership firm, as a proprietorship firm, with that of the respondent numbers 1 and 2. It is the stipulation at clause 1.1 of the contract agreement dated 31/1/2023 that a contract has been entered into by and between the petitioner, which is a proprietorship firm, with the petitioner, who is the owner of the proprietorship firm MS Rohini Gogoi, with that of with the ONGC. There is no mention, there is no it is an admitted position that there is no subsequent modification to the contract agreement dated 31/1/2023. Under such circumstances, the obligations so created by the contract agreement dated 31/1/2023 has to be obligations between the petitioner, who is the proprietor of MS Rohini Gogoi, with that of the ONGC. The partnership firm, it is well settled that a proprietorship, that a partnership firm is well settled that a partnership firm is distinct from a proprietorship firm. And as such, in the opinion of this court, the partnership firm cannot be brought within the picture, within the contract dated 30, within the contract agreement dated 31/1/2023, unless there is a novation of a contract in terms with section 62 of the Indian Contract Act 19 so and so. In that view of the matter, it is also an admitted fact that there has been no novation of a contract whereby the petitioner, the ONGC, as well as the partnership firm have entered into any form of a contract. This court also takes note of that a perusal of the terms of the contract shows contract agreement dated so and so shows that the petitioner representing, who is the proprietor of MS Ruhini Gogoi, is obligated to carry out the work for laying and maintenance of oil gas water injection effluent pipelines in Assam as said for 3 years period. And there is a reciprocal obligation of the respondent. Number one, ONGC, to make payment of the contractual price. In terms with clause 7 of the said contract agreement. Under such circumstances, it is the opinion of this court that till the contract agreement dated so and so continues to hold the field between the petitioner, who is the proprietor of MS Ruhini Gogoi, and the ONGC. The payment, the remuneration and the payment which is to be made as a reciprocal obligation by the respondent ONGC has to be in terms with the manner in which the petitioner seeks. The respondent ONGC on their own cannot unilaterally change unless there is an amendment to the contractual agreement, contract agreement dated so and so. Accordingly, this court therefore disposes of the instant with petition with the following observations and directions. The respondent ONGC, the respondent numbers 1 and 2 are directed to make payment to the petition, to make payment as per the terms and conditions of the contract agreement dated so and so. To the bank account of MS Ruhini Gogoi, which is a proprietorship firm, and deduct taxes after deducting the necessary statutory income tax. Against the PAN card number AGA PG 1980 and the GSTI number and the GST number, which is required to be taken into consideration while effecting such payment, would be the GSTIN of the proprietorship firm of the petitioner, that is 18 AGA PG 1980 BI B1ZV, which is linked to the vendor code 824091. This code have not expressed any observations on the dispute between the petitioner and the respondent number 3 and 4, as well as regards the dispute pertaining to disputes pending before the criminal courts. What is the called? What is the dispute in respect to CR case number?
3319/2025.
Pending.
For JMFC Kamrup at Gauhati.
And title suit number. How much?
30 of 2025.
Of along with the injunction application registered as Ms. case number so and so.
59 of 2025.
The said disputes between the petitioner and the respondent numbers 2 and 3, 3 and 4, shall be adjudicated by the concerned courts without being influenced by the observations made herein above. Anything else?
My case in the submission that I am entitled to the portion of the money to be released by province as per our mutual agreement. That is another of my
Absolutely not. This is not your petition.
my submission.
Submission is there. You have made all this payment. I have already mentioned out there that you claim that you should get the entire amount. You have spent 1,57,00,000. I mentioned all these things.
Grateful, Lordships. Grateful.
এখন দেখুন My lords, in code item 4, the officers are asking some more time, my lord. We are conducting a comprehensive study, my lords. The office of the PCC have written to my senior, my lords, seeking some time. Because this is not only confined to that NRL or Jorhat. This is not only confined to Jorhat or NRL. That plant, my lord, from which the petitioner procured the issue, that materials, my lords, it's all over Assam. So we are doing it, my lords, we need some time,
That is an important thing.
my lords.
Who are the other people involved out here?
My lords.
And how do you take care of it? You see,
My lord,
PCCF alone cannot do it. This I've asked it to the PCCF.
my lords.
The PCCF look into it. I think we should ask the additional chief secretary.
My lords. Yes, my lords,
Sure.
everybody's.
Ask the additional chief secretary because he alone cannot have. Now, can the additional chief secretary alone take it up, taking into account the other departments? You may look into only your thing,
My lords.
forest. Now, the other departments will be there. So, should you involve the chief secretary?
It will be better, my lords.
Better, no?
It will be
Because
better.
you see, the chief secretary can have many other secretaries look into this aspect.
My lords, my lords.
Very high time. Yes, Mr. Bigogoi. Mr. Bigogoi, what has happened is this. We have seen that as per Rule 5.1 of the Assam Minor Concession Rules, certain amounts are deducted. 5.1A, no problem, because there a contract is being given, it is a captive. It is more like a captive, where the forest department gives a contract, or the forest department gives the mining lease to the executive officer, PWD or whatever may be, and from there the PWD gives it to the contractor, and whatever is being taken, this is being done. That is no problem with that. But problem arises as regards 2 and 3, B, C, D, E. What happens in these cases? The amount is sought to be recovered on supply. Now, what has happened, for example, in as regards the petitioner's case herein, the petitioner uses a ready mix. Ready mix?
Ready mix,
Ready.
washing plant.
This ready mix is being purchased from somebody else. That somebody else manufactures it on the basis of purchasing raw materials which has sand and gravel. And that particular person purchases it from that person who sends the sand and gravel. And this person who has extracted under the sand and gravel, he is normally the requisite lessee in terms with Rule 8, Section Rule 8 and Rule 25 or 27.
25.
So what happens when you extract, you pay the royalty. So he has already paid. But what is problem in view of this rule? They are being asked, although they are submitting the ready mix, which they have purchased from somebody. Somebody has made it one. So that person has already paid. But how do you take care of this? And because of this, we see a lot of litigations. Am I right?
Right.
This is the case.
Yes.
So last time when the matter came up, I asked the PCCF to formalize what can be done. PCCF on the last occasion sought for time again. They also is seeking for time. The question is, can the PCCF alone do it? I think we need to involve the chief secretary. Because the chief secretary will be the head of all the departments. He can very well ask these departments to stock out a plan, how this can be done. Because this will lessen unnecessary litigations, huh? If by which they can very well formulate, come up with something that this particular document, if it is being shown, then in that regard, it will be, they did not pay. Yeah. So whenever it is, otherwise it will have far-reaching consequences. You keep on going because they are deducting the forest royalty. The Numuligor is deducting the forest royalty where he has never purchased. This also happens as regards the concrete mix.
Right.
Because this will involve all other people like this, all these big the cement companies, the Lafarge and all these things who have their manufacturing and use all these things. The machine which keeps on rotating, like in PWD, they put this concrete mix by all these contractors, but they get it from Lafarge or any other cement company. They get it. Now this Lafarge purchases this from somebody, and he already has paid that.
We hire the bashing plants, and bashing plants are owned by those companies. This is the case, man. And the court, in fact, has said that what is how you brought it, from where you bought it, whether they paid or not.
Next to impossible for them to get.
I have given all the, my lord, how I bought it, from where I bought it, how they paid. That also has been annexed.
Now, he can do it to a particular level.
Yes.
Because you may have it, but many of the people would not have it.
Yes.
Like I interfered with the GMC. GMC had passed an order to that effect that everybody has to pay a forest royalty at the time of building permission. I interfered with it because of the fact that they are not liable in view of the fact that they would not come within the ambit of 5, 8, and 27. GMC, no, for private persons, there is nothing to that effect. But here is a case where government public sector units comes into when they perform the contracts.
In fact, my lord, they have amended 20 Rule 21 also, which has been put to challenge by us. And we have 5.3 has been amended, saying that of the total cost project, 3% has to be paid. Not as a royalty. Royalty is like a fee, it is not a tax. But they now have changed and it is inconsistent with the forest, there's the Assam Mines and Mineral Regulation Development Act 1957.
No, in fact, if you see minus and there is a provision by which you cannot.
Yes.
That what they have done is wrong. I'll show you. That day I did not want to further embarrass the forest department. It is provisional.
Number same book.
To write it. Kindly see the 16.3
Of the,
15.3
of the, my lord,
of the Mines and Mineral
MMD Act.
act.
power of the state government to make rules in respect of minor minerals.
16,
15.
15.3.
yes.
15. The
Correct.
state government may by notification in the official gazette make rules for regulating the grant of quarry leases, mining leases or other mineral concessions in respect of minor minerals and for a purpose connected therewith.
Hmm.
Now this is the power
Yes,
by which the some minor minerals are made.
yes.
Now kindly 15.3.
15.3, yes.
The holder of the mining lease or any other mineral concession granted under any rule made under SAIA shall pay royalty or dead rent whichever is more in respect of minor minerals removed or consumed by him or by his agent, manager, employee, contractor or subleasee at such rate so and so. So it is either by the holder
Yes,
who has to do it. You see, this is a very important provision. Holder of the mining lease or other mineral concession granted under any sub rule under so and so shall pay it. And who else is to be paid? Either by him.
yes.
Now you see, or
Consumed
by
by
his
him.
agent. Means if he does not pay, his agent pays. Or his manager. Or his employee. Or the contractor. Means, just for example, as per 5.1, you give it to the PWD. The PWD is the mining lease and his contractor will pay. Or his subleasee at the sub rate. So therefore, my question is, how will these petitioners be involved? This is the power.
Yes. No, please. One, I'll just to draw your lordship attention. Now, one.
This I did not put it in that order.
No,
Not to
my lord will kindly see now 9. See 9.
Huh?
9 is
Please
not
see
applicable.
9. Your
No, 9
lordship
would
has seen
not apply,
15.
9 is not applicable.
No. Royalty in respect of mining lease.
No.
14 may be
yeah. See
14.
14. 5 to 13 is not applicable to minor.
Uh,
Therefore, this is the only provision. 15 is the only provision.
No,
There's
15
no other provision.
The power of the state to make the laws, make the rules.
And
Accordingly, yes,
and only this holder,
yes.
as per 8 and 13 and 5. So if he has nothing in connection to that, the rules becomes ultra vires.
Now
But I didn't want to.
But
this is the main problem, you see. So if that is so, if he is not the lessee of these, we can very well deal it. If you are taking time, no problem. But if he does not fall within the ambit of these 5, or where is your power? The power has to be traced to 15.
Yes. That is agreement.
Huh?
That is
now,
agreed. 15.
now this act, they brought it by a rule because of 15.
No, because
15.
because it is
15.
only by way of a rule
15
can be.
because the power of the under this act, you make rules. It has been given empowerment to the state to make the rules. In pursuance to that, under 2013 Assam Minor Mineral Concession Rule has been framed by them. Now, this 15.3, this is very relevant.
Yeah. So therefore, unless you come within these, there cannot be a deduction. They are not liable. Then you apply the law of income tax. It's a very interesting sing killing. I think yes, sing killing. That is on section 1026 of the Income Tax Act of 1961, wherein it says that when there is no requirement of payment of tax, income tax, there is no question of deduction of tax. So therefore, for persons who are deriving income belonging to the scheduled tribes within the area, there cannot be a payment of income tax. So there cannot be also a poorly deduction. Deduction is only permissible there. So here, the deduction is to be paid, can be made from you, by you, only if he comes under 15th.
53, but right, my lord. Either is a lessee or an agent or a manager or a contractor. Otherwise, it will be amounting leading to a double taxation. If this
Not
is, if I have to
no,
pay,
it will not only be a case of double taxation, it would be a case
divorce-
where it is not authorized.
no, it is under divorce of 15(3), it will be
Ah,
not.
because the rules cannot go contrary to this.
Yes.
Think on that. I
Right.
won't make anybody a party. Today I'm tired dictating. For the morning I've been dictating. This is the sixth judgment, long judgment, fifth judgment.
In fact, I did not.
15 lakhs, 18 lakhs, they are enjoying my money.
No, Malad, it's not with us. It's with
Whoever it is.
Yeah, whatever may be. My question doesn't arise.
So we are on a different,
Mr.
bigger
Gogoi,
picture
you
with us.
look into this.
Fine.
I'll ask you on the next day. Wherever the people, I will ask them. Now we will formulate it.
Well,
Is the PWD there?
no,
Finance there?
no.
Nobody. Who's there?
Only forest and NRL.
But for bylaw, for this issue, is a larger issue, your lordship can make them you call them, my lord. There is no impediment, your lordship can call them. Is a larger issue, your lordship is deciding it. Lordship wants that we should make a party, we'll make it.
The central government, all other ministries except the railway ministry are same. All other ministries. Therefore, you have a common budget, but railway has a different budget. Isn't it?
Yeah.
In a state of Assam, all other ministries are different except the forest. Isn't it? The forest does not come. Forest is different. Land laws do not apply to them.
Yes.
Forest regulations.
Yes.
Yeah.
Forest has different protections, environment protection, this protection, that protection. They get more money.
More.
Yes, royalties.
They have lots of money. Forest has lots of money. They may even lend it to the finance. Therefore, you answer on this.
Well,
Otherwise, I think we need to pass an order thereby it will take care of all.
Yeah.
This is an issue which need to be, because if you have to bring them anybody, so we have to say that Rule 5 has to be limited in its application in respect to these.
right.
It solves the issue.
Right.
There will be no case. There will be no case.
Mr. D. Gogoi now is busy with two men. One is the forest eviction and the other is the, what do you call that? MSME.
Missing my list.
MSME is a very dangerous with PhD.
Well, I've decided to stay away from that one. I don't go for that one.
Day before yesterday I got one matter. 2019 order being passed for payment of interest. And no contempt, representation has not been disposed of. And maybe I've asked Mr. R. Gogoi to file. Anyways, this court have granted various opportunities to the PCCF to devise to place a modality so that unnecessary litigations arising on account of deduction of forest royalty by the corporations as well as the government in respect of materials that have already suffered forest royalty do not further arise. In spite of providing ample opportunity, as nothing has been forthcoming from the PCCF. This court have duly perused the provisions of the Assam Mines and Minerals Development and Regulation Act 1957, and more particularly to Section 15, which empowers the state to make rules for the purpose to make rules in respect of minor minerals. Section 15(3) of the Mines and Minerals Development and Regulation Act 1957 empowers the state to make rules for the collection of, for the purpose of payment of royalty or dead rent, whichever is more. in respect of minor minerals removed or consumed, either by the holder of a mining lease or any other mineral concession granted under the rules or by his agent, manager, employee, contractor, or sublessee at the rate prescribed for the time being in the rules framed by the state government in respect of minor minerals. Under such circumstances, this court would like to hear the respondents in the forest department, would appreciate submissions from both the side, from the petitioner as well as from the forest department as to what extent the deduction of tax, deduction of royalty is permissible in terms with Rule 5 of the Assam Minor Minerals Concession Rules 2013. In terms with Section 15(3) of the Act of 1957. When
Unless I need 4 weeks time. Because they're also preparing something.
ask them to look into something, because you see, I also want the government should get the money, but how? But there cannot be double the royalty.
Yes, madam.
That is the only thing, because you also need to find out something.
madam.
Because every time they will collect, they will file case, and you are also not getting the money because of something.
Madam.
And you, once using the money, it becomes very difficult for you to spend it.
Madam.
Again, return it back.
In fact, in some matters, when the PWD officials, though they say it's forest royalty, that money doesn't come to us. It's directly deposited treasury.
Yes.
Then we are facing contempts out there.
So therefore, they don't get it. And these royalty, in fact, that day, Mr. Gogoi, I was taking up one of these matters. You were appearing out there. This matter pertained to, did I dispose of the petition wherein the contract in question, I said as to whether there is only payment of royalty or anything more than that.
That Karbi Anglong was involved, my lords. No, Lordship has issued some notice, my lords. Karbi
Now, the
Anglong is
question
involved,
is
my lords.
whether it is, you don't take any price for it, because normally when that is the PWD.
Yes, PWD was given.
You granted the contract to the PWD, and the PWD thereupon gave it to that particular. No, I dismissed the petition.
Dismissed, my lords.
I dismissed the petition. It was done by one lawyer named
Sinha.
Sinha. I dismissed that petition. I remember that.
Ultimately, royalty is a fee, it is not a tax. Royalty is a fee, it is not a tax.
Therefore, the question is whether here again there is a problem which has happened in that contract where he was appearing out there. I have put a question to this. Now, they have granted the extraction or mining right to the PWD, some executive engineer. Now, while doing it, they are only asking for certain amounts, royalty and all these funds.
DMFT.
I put a question to Mr. Gogoi as to whether it is permissible only to ask this, not the others, because the counsels for the petitioner submit that why should they make anything more? But normally what happens when they grant a contract, they contract that so much CUM you are going to extract, this is the amount. Whoever is the highest you pay. Apart from that, there will be a payment of royalty because they are extracting by virtue of this act.
Yes.
So therefore, how in that case they have only fixed the royalty? That was the issue I put there.
Sometimes the government, what they do, while DPR is prepared, they identify that these are the area where you can extract it. For that purpose, you have to pay the royalty.
Because you see, if these forests and all these things, they get the money, they can invest it for better things. No? Anyways, when do we fix it on 27th August?
Miles, 27.
4 weeks?
4 weeks, Miles.
This is the matter on 27th of August 2026 for further hearing.
Simply.
Any more matters? No more?
The item number six.
You with that case,
My lord, we are now hoping, my lord, that lordship may give some way, my lord. He's now jobless on state, my lord.
can't help you with that.
My lord, only one thing, my lord, only one thing, my lord, because my lord, my representation till yet has not been, my lord, my representation in terms of the direction given by this honorable court.
What
Now,
represent-
for regulation, my lord, but that has not been in between, my lord,
You wait.
my lord,
for regulation. You are a sweeper.
my lord, casual employee,
Peon, my lord.
peon, my lord.
Sweeper is another case. Beyond regularization,
My lord.
how many years you have worked?
My lord, 2014 I joined.
Recently. Not even 10 years.
No,
The amount of filing of litigations he have done, he did not come under Uma Devi also. What about the recent judgments?
my lord, my lord, the Dharam
Not
Singh.
Dharam
case.
Singh. Dharam Singh would not come.
After all, my lord, Bholanath, my lord.
But nowadays, what is being said?
My lord, what
My-
happened, my lord?
My lord,
This
Hezi-
case was rejected due to suppression of the facts. Uh, for the second time, he approached your lordship, my lord. In the first time and as well as in the second repetition, he never mentioned that he is overqualified.
But that is pertaining to my lord, the appointment that has
My
my
lord,
lord, that's
now-
been rejected. Now it's a matter of
Now he has
regulation.
filed a representation before the authority. Yes, condone my this part also. Condone my age in the first repetition. Your lordship condone his age.
What is your qualification?
My lord, my
It is
qualification
passed, my
higher secondary, but question is that, my lord, that earlier issue was dealt with in respect of, my lord, the appointment process that has been initiated. Now I have been rejected. Now this issue is over. Question is that, my lord, so far the regulation part is concerned, 10 years I have completed, my lord, and there is a representation which has been submitted till it not disposed of, my lord. Now, without disposing of that representation, my lord, all of a sudden, my lord, the termination letter was issued, my lord. Now, termination letter,
Termination, you got the money because it was fixed till the particular period.
Yes,
no doubt, my lord.
Extension granted by them.
My-
So
my lord,
thereby
kindly see-
you don't get a right out there because you
Lordship,
cannot impose
Lordship, kindly
government
see
to
on
them.
last occasion, Lordship, page 41, Lordship
No,
observed.
my question is, if your posts out there have already been filled up,
No, my lord, posts are still there, my lord. Vacant posts are still there, my lord.
no, there was some proceedings.
My lord, the advertisement was done, age was condoned. Thereafter, as per the advertisement, he is supposed to furnish the declaration regarding his qualification. There, my lord, he came up with the representation, I am HS pass, my lord, that that overqualified part may be condoned.
No,
That was
no, no,
rejected, my lord,
no,
and my lord, the entire advertisement part is kept in abeyance.
my entire read is on regulation, my lord. Kindly see page 19 of the
My
read
lord,
petition.
how we
That is
can
the subsequent development. While this petition was pending, my lord, they, my lord, issued advertisement. Therefore, I would like to participate. That was rejected, my lord.
My lord,
Mr. Samare, there's
My
a
lord.
big problem. As regards your qualification
My lord.
to be condoned, if we do it here,
My lord.
pass the direction here, it will open up
My lord, absolutely, quite right, my lord. I agree to that.
open up floodgates.
My lord,
And
absolutely.
put
My
it
lord,
that
that's why, my lord,
in
appointment.
fact, you see, there is a basic idea.
Well-
Why the peons have been put at a particular level, because otherwise, we have seen out here,
My lord,
nowadays for drivers, people who are MA, MSc, they come.
my lord, absolutely, my lord.
And it becomes, and what happens, last time, it was the best part was this. This time there was some advertisement for drivers.
My lord.
People who are MSCs,
PhD.
they came over. Fantastic. The person who actually are drivers,
My lord,
they are not in a position to, they drive well.
my lord,
But these MSc people, they don't know how to drive.
my lord.
So what has happened? They all got fantastic marks in the written.
Absolutely.
But when the question came before that particular officer,
Then, my lord, situation.
driving test, my lord.
My
carrying out the test,
my lord,
everybody flunked.
my lord. Yes, my lord, that is
And
the reason.
therefore, now what has happened? We have to go for a re-advertisement.
Absolutely, absolutely, my lord, absolutely.
Thinking about something. You see, Mr. Gogoi, this is a big problem.
Practical scenario is different.
And they little bit.
My lord,
And normally what we are having here,
my lord.
just for example, the drivers.
My lord,
Because of this MAC, after working for a few years,
my lord,
they immediately go for promotion
my lord.
to the post of JA.
Yes, my lord.
And this post is vacant.
Yes, my lord.
And again, another person comes, and thereby the persons who are actually driving, they're not getting
They're
it.
not getting, my lord. And those are working since long, my lord, even in that institute.
Similarly, in your case also, you have been overqualified, whatever maybe it's a different thing, you have been there.
My lord.
Now, for regularization is another concept,
My lord.
which is there as per how it can be considered and all.
My lord, lordship may fix a date. Lordship, I will place my some case, whatever, my lord, and lordship decide. And
But not for, I'm not going to consider the question of relaxation.
no,
The
relaxation chapter is off, my lord. That
goes
chapter
on
is
the
off.
question of policy.
Yes, absolutely, my lord. My lord,
My
in the light of the
yes, my lord.
judgment, my lord, lordship may decide whatever this or that side, my lord.
Relaxation is on policy.
My lord, my lord.
But we take it up some other day. When?
My lord, next week, my lord.
Let's see on 6th of August.
My lord.
6th, no, not possible. 13th, 6th, we have a long.
My lord, no
division.
problem. Lordship convenient that, my lord, no problem. My only, my lord, at 2 p.m. Otherwise, the reaching of, my lord, sometimes, my lord, gets subject, my lord. That.
No more matters anymore, urgent, no matter. Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner expresses urgency in the matter. This court inquired with the learned counsel of the GAC as to why, as to what happened as regards the advertisement for the posts. The learned counsel submits that on account of the pendency of the present proceeding, the advertisement, the selection proceedings have been kept on hold. Taking into account that there is no interim orders passed out here in the present proceeding, it shall not be a bar on the part of the respondent GAC, the respondents to proceed with the finalization of the selection process.
My lord, only one question. Well, representation, my status of the representation.
Yes, sir.
Lordship.
Be that as it may, the status of the representations was submitted by the petitioner for the purpose of regularization
My lord.
shall be placed before this
My
court
lord.
on the next.
Deeply.
Is the matter on
Deeply.
13th. Once Mr. Bigogo appears for the finance department.
Omelette.